Yes, sir. Nagamatu.
May I
But Nagamatu, today by evening we have to finish this.
Yes.
Today, no,
Yes,
for
yes.
tomorrow. So, who is your opponent? Tell us first. In this case.
There is no opponent.
Yes.
Based on what?
Only assisting the court. That's all. No opponents.
No,
Not adversarial, my lord. Not adversarial. Should not be. And also, my lord,
Jain pointed out he will have a different take.
Mr. Jain said he'll take an hour.
He also said he had a different.
Jain. No. He was also not an opponent.
No, he is for the accused side, Malas. He said he had a different
Malas,
take.
no one is opposing the other, no, we are only stating what the law is.
Actually, there is nothing to oppose. Actually,
Yes.
we have to clarify and send it back to the division
Yes.
rather
Malas,
to the regular benches.
That-
My case is that applying all these things, I'm entitled for acquittal. That is on facts.
Actually, give about 10 minutes to me after. whenever-
Mr. Jain will address on this, whether this reduction can be made or not. Malas, he is on his left, Malas, by that time I learned in the colleague.
All right, send for him. But we have to finish this case today.
10 minutes after all this.
All right. Yes. Tell us now.
I will be very brief.
Yes.
But the other day I was highlighting the difference between obtainment as employed in section 13(1)(b)
Yes.
when acceptance as employed in section 7 of the Act. I submitted that obtainment means that the offer should have emanated from the public servant and that should have been accepted by the bribe giver, would have given the money. But so far acceptance is the reverse. Demand should have gone from the bribe giver. He will go and say, I will give you 50,000 rupees, you do this. So demand goes from here. In either case, demand is yes, I am on. If the demand is exclusively known only to the bribe giver, who is the complainant, through his evidence alone, this fact can be proved. If demand is not proved, then whether it is acceptance as employed in section 7 or obtainment as employed in section 13, it cannot be proved. This was my submission. And I also submitted partly that if there is any other witness who has got direct knowledge of the demand made, both for the purpose of acceptance as well as for the purpose of obtainment, his evidence will be relevant and based on that there can be conviction. This is one way of proving. The other one, I also submitted that if there is documentary evidence to prove either acceptance or the obtainment, by which it can be proved. Third one I submitted about the legal presumption. I refer to section 20 and I submitted that section 20 presumption is not applicable to 13 only, it is applicable only to 7. I also submitted section 20 presumption is only limited to presume that what was received was only as a reward or motive. That is a limited presumption. I also highlighted about section 114 of the Evidence Act, that is may presume, not what could be presumed, which requires foundational facts. Unless there are foundational facts not spoken by other witnesses, it is not possible to presume under section 114 of any fact. That also is submitted. Then lastly I submitted that the last course available for the prosecution is to prove either demand or receipt by means of circumstantial evidence, provided that is corrected during investigation. To my knowledge, in no case circumstantial evidence is relied on in PC Act cases. So this was the crux of my argument the other day. But the whole issue has arisen because either the defect of complaint is no more or he declared as hostile. But regarding that hostility, I want to rely on one judgment you will ultimately submit in compilation. But my argument will be, in Indian law, the term hostility is foreign. Never it is used in the Evidence Act. That no witness can be declared hostile by any court because it has got its own implications. For that, you will kindly consider section 154 of the Evidence Act.
No, Mr. Nagamatu, subject to what you may say. No, unless he is declared hostile, of course, we will hear you. How can he be allowed to cross-examine?
Yes, in English law, this is the judgment on that.
Because the same prosecution advocate for government advocate, APP has to cross-examine him. He
Yes.
leads and he cross-examines.
He can cross-examine, but witness cannot be declared as a hostile. witness cannot be declared as hostile, is my humble submission, but despite the judgment of this honorable court, that no witness can be declared as hostile, the practice is still prevailing in courts, declaring a witness first as hostile, then to allow the prosecution to cross-examine. That procedure is wholly illegal in Indian scenario, in the right of section 154 of the Evidence Act. But I will take you through section 154, then I will refer to the judgment also. 154.
Yes, we have.
If the court may,
Yes, we have. The court may.
the court may, in its discretion, permit the person who calls a witness to put any question to him, which might be put in cross-examination by the adverse party. But in a criminal case, adverse party is the accused when the prosecuting witness is in the box. Adverse party can very well cross-examine the witnesses, but as per section 132 onwards, you can cross-examine. No doubt about that. Now, Murad, the prosecutor cannot do the cross-examination, but with the permission of the court, he can do it under 154. But section 154 does not say that the witness should be declared as hostile. Who is to declare him as hostile? Whether it is the court or the person who has called him as a witness. Let us say not in the prosecution. Or the court, who has to declare him as hostile? The practice now is public prosecutor will make a request to the court to declare him as hostile. The court declares as hostile. Once he is declared as hostile, then the entire evidence is to be achieved from consideration. That is my humble submission. But it is not done.
No,
There are
but
several judgments.
there are several judgments.
Yes.
We say that even if a witness is declared as hostile,
Yes.
such part of his evidence,
Yes.
which can be treated as a trustworthy,
Yes. Any part.
you have to separate the chaff from the grain, and such evidence can be relied on. That is
True, Murad.
right from Kuji.
Absolutely true, Murad. That is a position of law in India also. Though a witness is cross-examined under section 154 of the Evidence Act, any part of his evidence can be taken into account and relied on that the court can act upon. No doubt about that. That is the law. But the question is, Murad, after treating a person as hostile, Murad, what was said, Murad, in several judgments, in my humble submission, is contrary to the judgment which I have now cited. 154 does not say that a witness is to be treated as hostile first. That too, Murad, declaration made by the court, and thereafter only, Murad, the cross-examination is permitted. That is what is practically being done in the court. That procedure is wrong. It was so declared by this honorable court, but this judgment is not followed, and that is the reason why today's problem has arisen. Because witness has turned hostile, does not support it.
So what is the correct procedure, Mr. Nagar?
Correct procedure is not-
In case he doesn't, his evidence is not in conformity with his statement.
Yes.
161 statement, whatever.
Yes.
What is the correct procedure?
The prosecutor has to seek permission to cross-examine, that is all. He is a witness for all purposes, like any other witness. There is no witness, like a hostile witness or unfavorable witness in India. Every witness is a witness. He is a prosecution witness. But normally, as per law, he cannot be allowed to be cross-examined by the non-adverse party. Adverse party has got right to cross-examine. But this is a peculiar provision which permits the person who calls him only to cross-examine. But the word hostile has not been used anywhere in the Evidence Act. More particularly in section 145. Your Honor, kindly have a look into the judgment, Murad. Your Honor, kindly come to compilation page 119.
So what you are suggesting is, if he is treated as hostile, his entire evidence has to
To
go.
go. As per English principle. As per English principle. That we have not followed, that has not been incorporated in the Indian Evidence Act.
Is it not high time that we follow our own law?
My lords,
How long we'll go on?
our law does not permit a witness to be declared by the court. It is a judicial function of the court. When the court says yes, he is.
No, but then what is the procedure? How can a prosecutor cross-examine the witness called by him?
But 154 simply says you take permission
Permission.
to cross-examine. For these reasons, permission is granted to cross-examine, but witness is never branded as hostile. Hostile means it presupposes unbelievability of that witness.
What is that?
Witness cannot be believed. It presupposes.
Unbelievable.
Totally cannot believe that.
Hostile means it should go. That was the English principle.
No, hostile also could be mean hostile to prosecution.
Murat, there are two kinds of witnesses. Murat, as per English principle, there are two kinds of witnesses. One, Murat, is hostile. The other one is unfavorable
Yes.
to the prosecution. Two types of witnesses.
So in the context, it is unfavorable. In the context,
Murat, in this reference, it is said hostile.
maybe 154 doesn't carry the expression, you know.
Either hostile or unfavorable. There are two types of witnesses.
No, to cross-examine your own witness, you
Yes.
need permission of the court.
Four, yes. That is true, Murat. That is under 154. But it is not after declaring the witness as hostile. Murat, may I kindly see Murat, the difference between English law and Indian law. Murat, in English law, witnesses are branded into two categories. Number one, Murat, hostile witness. Number two, unfavorable witness. Murat, so far a hostile witness is concerned, he cannot be contradicted. He can only be cross-examined. Murat, section 145, Murat, may I kindly have a quick look into section 145 also of the Evidence Act. Murat, may I kindly come to section 145, Murat. A witness may be cross-examined as to the previous statement made by him in writing or reduced into writing and relevant to the matters in question without such writing being shown to him. This is out and out cross-examination and there is no contradiction elicited from him. He is not contradicted. First part. Let me kindly come to the second part. But if it is intended to contradict him by the writing, his attention must, before the writing can be proved, be called to those parts of which are to be used for the purpose of contradicting him. But so far, a first part is concerned, it speaks only of cross-examination, no contradiction. But if a witness is hostile, as per English law, he can only be cross-examined, not contradicted. If a witness is unfavorable, but as per the latter part of section 145, he can be contradicted by means of the previous statement. Then, if he is so contradicted, then his evidence is, credibility is impeached under section 155, which provision I already referred to your lordship, 155. Now, I am not saying anything new, your lordship kindly see the judgment. But all these things have been like a research work done by this honorable court. But your lordship kindly come to the compilation page 119. Tatpal versus Delhi administration, two-judge bench, Honorable Justice R.S. Akaria has authored the judgment. Your Honor, may kindly come to page 131 of my compilation, paragraph 29. Top on right hand side corner, my compilation page is there, 131. Paragraph 29 at the bottom. Since this vexing question frequently arises and the observation made by the court in Jagmeet Singh case supra do not appear to have been properly understood, it will be appropriate to clarify the law on the point. One, the term hostile witness, adverse witness, unfavorable witness, unwilling witness are all terms of English law. At common law,
What about tutored witness? Only known to Indian law.
Yes.
that is not Tanjurian law.
And both of us know better.
Tutored witness. Nagamatu, Desi jurisprudence.
Tanjurian law,
Thanks.
really is not belong to Tanjurian.
That is still more desi. Strong desi.
Put this.
Adverse witness, unfavorable witness, unwilling witness are all terms of English law. At common law, if a witness exhibited manifest antipathy, attitude to the cause of the party calling him, the party was not, as a general rule, permitted to contradict him with his previous inconsistent statement, nor allowed to impeach his credit by general evidence of bad character. This rule had its foundation on the theory that by calling the witness a party represents him to the court as worthy of credit, and if he afterwards attacks his general character for veracity, this is not only malafide towards the court, but it would be enable the party to destroy the witness if he spoke against him. Malad, I skip Malad few lines. Malad, Ratma kindly come to paragraph 33. Malad, I am skipping the other things. Now, there were views Malad in support and against also they are dealt with more up to paragraph 32. Paragraph 33, the rigidity of rule prohibiting a party to discredit or contradict its own witness was to an extent relaxed by evolving the terms hostile witness and unfavorable witness. There are only two types of witnesses. And by attempting to draw a distinction between the two categories. A hostile witness is described as one who is not desirous of telling the truth at the instance of the party calling him, and an unfavorable witness is one called by a party to prove a particular fact in issue relevant to the issue, who fails to prove such fact or proves an opposite fact. So there are two types of witnesses, hostile and then you let me kindly come to section 37, paragraph 37. The construction of these provisions, however, continue to cause difficulty, particularly in their application to unfavorable witnesses. In so and so case, these provisions were found to be confusing. That Cockburn CJ said that there has been a great blunder in drawing of it, and on part of those who adopted it. To steer clear of the controversy over meaning of the terms hostile witness and adverse witness, unfavorable witness, which had given rise to considerable difficulty and conflict of opinion in England, the authors of Indian Evidence Act of 1872 seem to have advisedly avoided the use of any of those terms so that in India, the grant of permission to cross-examine his own witness by a party is not conditional on the witness being declared as adverse or hostile in Indian law. Whether it be the grant of permission under section 142 to put leading questions or the leave under section 154 to ask questions which might be put in cross-examination by the adverse party, the Indian Evidence Act leaves the matter entirely to the discretion of the court. The discretion conferred by section 154 on the court is unqualified and untrammeled and is apart from any question of hostility. So no question of hostility so far Indian law is concerned. It is to be liberally exercised whenever the court from witnesses, demeanor, temper, attitude, bearing, or the tenor and tendency of his answers, or from a perusal of his previous inconsistent statement, or otherwise, you let me kindly highlight this, or from a perusal of his previous inconsistent statement, or otherwise, think that the grant of such permission is expedient to extract the truth and to do justice. The grant of permission, such permission, does not amount to an adjudication by the court as to the veracity of the witness. Therefore, hostile witness cannot be declared as hostile by the court. Therefore, in the order granting such permission, let me kindly consider this is very important. Therefore, in the order granting such permission, it is preferable to avoid the use of such expressions such as declared hostile, declared unfavorable, the significance of which is still not free from the historical cobwebs, which in their wake bring a misleading legacy of confusion and conflict that had so long vexed the English courts. So we have to avoid. So mere permission to cross-examine. And he can also be contradicted. Permission to cross-examine includes to contradict because it is provided in section 154. So therefore, my humble submission should be, Murad, no witness can be declared as hostile in India. But this judgment, Murad, is not followed. That is the wonder. Now you will kindly consider paragraph 40 of 39. declared as hostile, then the evidence cannot be put into for any purpose. Because
There are so many judgments. There are so many judgments which says that the entire evidence cannot be discarded.
But I fully agree with you, Lordship Mullah. There are several judgments. That is a settled position of law. I got no quarrel over that. But my humble submission would be
And of a bench strength larger than this.
that there are judgments.
Noticed.
Mullah,
Maybe
there
the
are-
procedure what you are suggesting is incorrect.
Yes.
You have to simply say, if the witness is, his statement is
Inconsistent.
inconsistent or not in support of the prosecution, then the prosecutor has to seek permission.
That is all.
Then the court will examine and grant permission or otherwise.
Yes.
This is the correct procedure, right?
Right position.
Hmm.
The significance, Mullah, of this is,
Hmm.
Mullah, if as it has been observed, Mullah, in Indian law, these words, adverse, hostile and unfavorable witnesses, which had given rise to considerable difficulty and conflict of opinion in England, the authors of Indian Evidence Act seems to have advisedly avoided the use of any of these terms in India. Why they have avoided? They could have simply incorporated the principle.
Who are the framers of Indian Evidence Act? Again, Englishmen only, 1870.
72.
Stephen Mullard, sir. Mullard, he has authored one wonderful book, Mullard, about how he made this law. That book is very, very interesting to read. We have said about this also. Mullard, in the judgment itself, Mullard, there is a reference about the book.
St. James Stephens.
It is there. Mullard, then you Atma kindly consider paragraph 41.
No, maybe at that stage,
What is the effect?
maybe at that stage you should not say hostile. Because before considering all evidence, you are branding a witness. Branding a witness.
As unfavorable
Yes.
or hostile. Not
That's,
branding it.
that's the reason.
Mullard, it is at the time of judgment, it is for the court to say,
Yes, yes.
yes, whether his evidence is
He
credible.
may be truthful also.
Yes, truthful also. Therefore, don't brand him.
So once you treat him hostile,
Yes.
the statements in favor of the prosecution can't be accepted.
Yes,
This is what perhaps,
court declared that he is a doubtful man.
and how can you rely on
You're
that?
branding him a liar.
Yes, liar. Yes, and he was a liar. So that finding can be given only in the judgment after hearing the
It
argument.
may, it not. But in effect, the answer is in para 52.
Perhaps I will read that one. I will read paragraph 42, then I'm not.
It's only
Tell this
some procedural aspect.
before.
The practice which has been followed for ages. That a prosecution witness, whenever the prosecutor finds that he doesn't support the prosecution case, he seeks leave of the court to cross-examine him.
He has to
He has to.
necessarily.
So
But
as a matter of practice, before granting permission, he might be declared as hostile. So how it turns? Anything turns on that, because the consistent law is that his entire evidence is not washed away. Such of his evidence which can be found to be trustworthy and reliable.
My humble submission.
Even this judgment says so.
But
What
my
he's trying
humble
to say
submission
is
is very
it
simple,
is
ma'am.
not necessary to say at this
It's not a question referred to us.
No, there is, Manoj. There is, because it's somewhat relevant because when the defector complainant, the bribe giver, turns hostile, what is the position?
So many trials which have been.
Yes, 41.
Yes, Manoj. Unmindful of this substantial difference between English law and Indian law on this subject, paragraph 41. Unmindful of this substantial difference between English law and Indian law on this subject, the Calcutta High Court in some of its earlier decisions interpreted and applied section 154 with reference to the meaning of the term adverse in English statute as construed in English decision and enunciated the proposition that where a party calling a witness requests the court to declare him as hostile and with the leave of the court cross-examine the witness, the latter's evidence should be excluded altogether in criminal cases. So if it is Calcutta High Court was once he declared as hostile, now there is a judicial declaration.
That view has not been found to be correct subsequently. The court finds that this view is not correct.
True,
And on that also on the basis of English judgments.
absolutely, absolutely. Therefore, my humble submission will be, let us not follow the English law. English law is different.
What is the Indian law? The Indian law is same.
Indian law says no hostility. Don't declare by a judicial order at the threshold.
Only this judgment. Only this judgment.
Three judgment. But it's a like a research, but I have not read the entire judgment.
Justice Sarkaria's judgment.
If
Justice
you have to
Sarkaria.
find time, not you have to kindly read the entire judgment. It's like a research work, wonderful judgment. Not highlighting, not how it.
See, ultimately, what is the result? Para 52.
2 minutes, what I am submitting is, let no witness be branded as hostile. Let no witness be branded as unfavorable. Even before giving a finding on that, don't declare him. But it is a judicial declaration made when the evidence is being recorded. When the evidence is being recorded, there is a judicial declaration that he is an unfavorable witness. He is hostile. No.
That is not a condition precedent for exercise of power under section 154.
Yes.
They can just say at this stage permission is sought under section 154 of the Evidence Act.
Only to
cross-examine.
cross-examine. Only to cross-examine. Do that. But don't brand him at that stage.
Yes.
Hostile, the only meaning of hostile is hostile to the case of the party calling him.
No, who declares it? Court.
Yes,
So because at
Court.
at the request of the party calling him.
But he tells the truth in court. He tells the truth.
Prosecutor, firstly, he cannot put leading questions without the leave of the court. So in his examination in chief, it is found that he doesn't support the prosecution case. Then at that stage, the prosecutor makes a request.
Yes. To
This
cross-examine.
is a practice forward way, declaring him hostile, not hostile to the justice, hostile to the party calling him.
But so far as the witness is concerned, he is telling the truth in court. He is not telling any lie. He claims that you have called me on someone, I have come to the court. On oath, I am telling the truth. Why should you declare me as hostile? Why do you say that I am a false witness or I am a hostile witness at that stage?
now the problem is,
Yes.
we are starting with the presumption that the word hostile is an ugly word. But it has a reflection upon the character of the individual. It is not so. Hostility can arise of it. He is hostile to falsehood. I can be hostile to falsehood. I can be hostile to injustice. Where do you put the term hostile there?
Yes.
Can I be hostile to falsehood or not?
Yes.
Can I be hostile to injustice or not?
True.
Therefore, hostility this understanding has arisen out of treating the word hostile as an ugly word. It is not so. He is hostile to the party calling him to the witness box. He is hostile to falsity. Therefore, he is speaking the truth. It can be either way. Therefore,
He is telling the truth.
And what is the truth in his evidence or not?
Yes.
Has to be found out by the court
Yes.
from appreciation of his entire evidence.
At the end.
At the end.
At the end. Correct.
the long line of decisions which say that despite the court passing around, let us start with the understanding that such a declaration is not correct in law. Fine. But courts have repeatedly held, despite such declaration, the entire evidence is not washed away.
Right.
If that is so, the courts, despite declaration of hostility, have not treated him as a false witness. They are still prepared to give credibility to some portion of the evidence. Therefore, the courts have understood the term here, not as a bad term, not as a term which connotes the bad character of the individual.
Why the distinction between English law and the Indian law needs to be highlighted is this. If a witness is treated as hostile, as per English principle, he can only be cross-examined by the party who is calling.
No. He can also be cross-examined by the accused.
No, he can. That right is always there. That is why adverse party can be cross-examined.
Merely because the prosecutor.
No, I am not saying that. But he can be cross-examined. That right of the adverse party to cross-examine is always available. Normally, new right is created only for the prosecution to cross-examine. If a witness, as per English law, is treated as
I think
hostile.
if we read para 52, it will bring more clarity.
True, Mulad, I will highlight this, Mulad. You have to
First, I think first we'll read para 52 and then,
Mulad, few minutes, few seconds, you have to permit me.
but ultimately what has been held is in para 52.
Mulad, I will answer the query raised by his lordship. Mulad, the distinction is, Mulad, if a witness is treated as hostile as per English law, he can only be cross-examined by the party who has called him. Only cross-examination, no contradiction can be elicited from him. If he is declared as unfavorable, there is another kind of witness, unfavorable witness. Unfavorable witness means Mulad who has not stated what he stated in his previous statement. He is unfavorable, not hostile. The distinction is between unfavorable and hostile. Hostile means who is not speaking something which is expected of by the party who has called. That witness can be allowed to be only cross-examined to elicit the further facts. Only cross-examination. He cannot be allowed to contradict. That is also dealt with the judgment. Suppose the witness is declared as unfavorable, not hostile, unfavorable. Then Mulad, he can be allowed to be contradicted by his previous statement. So that is the distinction, Mulad, in English law between a hostile witness and unfavorable witness. Now, here, Mulad, in India, we have been using the term hostile in every situation. We do not use the word unfavorable. As per English law, if the witness is only unfavorable, he can be contradicted with the use of the previous statement. But in no case we use the word unfavorable in India.
That is because these finer distinctions of syntax, the meaning, etc., being a foreign language, we have lost. There is a law which says that the practice of the court is also the law of the court. Correct? Therefore, if we have followed in a long line of decisions, maybe loosely understanding what we mean, mixing of both unfavorable, adverse, hostile, etc., then that position should be left undisturbed.
Yes, Mulad.
Therefore, Mr. Ramod, if you read para 52,
Yes, Mulad. Yes. From the above conspectus, it emerges clear that even in a criminal prosecution, the witness is cross-examined and contradicted with the leave of the court, not after declaring as hostile. By the party calling him, his evidence cannot, as a matter of law, be treated as washed off the record altogether. It is for a judge of the fact to consider in each case whether as a result of such a cross-examination and contradiction, both are there. Contradiction, the witness stands thoroughly discredited or can still be believed in regard to a part of his testimony. If the judge finds that in the process the credit of the witness has not been completely shaken, he may, after reading and considering the evidence of the witness as a whole, with a due caution and care, accept in the light of the other evidence on the record that part of the testimony which he finds to be credit worthy and act upon it.
So this
Yes,
is in reference to the Calcutta High Court, wherein Calcutta High Court holds that once a witness is declared hostile, his evidence is totally washed away.
They followed one of the English principles.
And this judgment is also following certain other English judgments.
Yes, Mulad. So therefore, Mulad, my humble submission would be, Mulad, as it has been held in this case, there are two types of witnesses, unfavorable or hostile, but in no case Mulad, we declare any witness as unfavorable.
Hostile or not.
Is very interesting.
This is very interesting, but then you can't read a judgment in piecemeal.
No.
You have to read in entirety. This is in
Yes,
answer to what the Calcutta High Court holds in para 41.
In para 41, Mulad, the Calcutta High Court said that because the witness is declared as hostile,
His entire evidence is required to be excluded.
washed up, they applied to the English principle.
English principle.
Now, this court says, don't declare him as hostile. Allow him to be cross-examined or contradicted. Then keep it open for you to decide. At the end, you may decide from out of his evidence and all the other evidences, whether a part of the evidence can be taken into account, can be believed. You keep it open. That's what the judgment says. My lord, Calcutta High Court followed the English principles.
So therefore, mere declaration of a witness as a hostile does not wash away his evidence. And this principle also is on the basis of the full bench of Calcutta High Court, which relied on two English judgments,
Yes, my lord.
the King versus Norton and Percy William versus Adams.
Yes. Yes, my lord. Therefore, I am
So
submitting.
merely declaration, it's only a matter of practice, procedure, followed for years together.
Practice of being followed by the trial court, my lord, is found to be not in accordance with 154 as highlighted in this judgment. But I think, I am justified in placing before this honorable court that this practice, which is contrary to 154, should go. But why should a witness be declared as hostile? Why should, I am coming to the court as a witness. I tell the truth. But even without examining the correctness of my evidence, you declare me as hostile, you say that I am unfavorable. But it is a stigma on me. Therefore, kindly don't do that. It is my.
He is declared hostile only when he doesn't support what has been stated by him either in 161 or 164.
But I am not expected to speak what they expect. But I am here on oath to tell the truth. I am telling the truth as far as I am concerned.
Therefore, you are hostile to falsehood.
Yes.
If you are hostile to falsehood, is it a credit to you or a discredit to you?
I am favorable to truth always.
Therefore, unfavorable to falsehood,
Yeah.
adverse to falsehood.
Yeah.
So these terms can be used both ways in conjunction with the opposites,
True.
extreme opposites,
True.
to mean different things. Hostility, we don't think, is a bad term which reflects the character of the individual. In fact, see, why witnesses turn hostile? One, either because of their desire to speak the truth.
He has got some instruction.
Either.
What are these?
No, does he want, does he want to turn you hostile?
Or is he hostile to you?
Unfavorable.
See, the word hostile is used in the loose sense. It is used in the loose.
Interpreted to this extent. On what basis the witness can be declared in case even if it does not favor to the prosecution? Now, answer to this query, that in case even if the statement under section 161 of the CRPC that has been recorded, which he never disclosed to that extent, can he be declared as a hostile? So this is the modern question that needs to be given reply by this honorable.
He is also right. But I do not know what is contained in my 161 statement. It does not contain my signature because my signature is not obtained under section 161. There is a bar. Something is written there. So they say, they read that I am asked to tell the truth on oath. I say the truth. They say, no, it is not contained here. Therefore, he is hostile.
So if at the end of the trial,
Yes.
the court finds that you are correct,
Yes.
then court will
Accept.
give a finding
Yes.
that the evidence of such and such witnesses is truthful and the prosecution case is false.
Yes.
In which case, what happens?
Nowadays, why that word is being used by the judges is,
The prosecution.
Yes.
nowadays, why that word is being used, it is in a loose sense, in the sense that if the witness is hostile to the prosecution's case, he is declared hostile.
Declare hostile.
That is not correct in the legal sense.
That's what I am submitting. Don't declare by a judicial order.
In a loose sense, it is being used.
On the contrary, if the evidence of such witnesses is found to be trustworthy, there are matters where at the end of the trial, there would be strictures against the prosecution. That the prosecution has falsely made out this case, so there was nothing against the accused.
Yes.
Yes. So at that stage, the so-called stigma
I am speaking in trial courts what is happening. If a witness is treated as hostile, he is seen as an untouchable. No, he is a hostile witness. Don't look into this.
No, but there are a series of judgments, right from Kuji.
True,
One more aspect, if you lordship can just consider. we can't go with the presumption that whatever witness has said before the police, because we know the police,
Yes.
whatever statement the police is recording, witness is never consulted even, and the statement is recorded. Now, our normal presumption in these days is that whatever statement given in the police is the correct statement, and if contrary to that is become, that's what is declared hostile.
Hostile.
That is again a notion that has to be corrected. Ultimately, a statement made before police officer is not treated even admissible
Yes, yes.
because of the historical background.
No, not even a statement made under section 164.
Yes. So
Yes,
if
yes.
that is the position, my lord, today sometimes in some of the cases we have seen there is a perjury proceedings. How can a perjury proceeding, that statement cannot be treated as true version
No,
even?
perjury proceedings for not adhering to
It
one
might have said as something else, and the police might have recorded something.
No,
different.
perjury proceedings for not adhering to 161 statement.
Yes, Lord.
You are saying that there are perjury proceedings for not adhering to 161.
Right, it is not,
161,
right, it is not uncommon. Right, it is not uncommon. It happens in the country.
In our country, anything is possible. Oh, police statement is there. It's a gospel truth. Yes, by the grace of Almighty, if completely trust, he could be also prosecuted on the basis of declare husband under section 182 of the IPC, but he not able to prove that. So this is very critical matter and which needs to be discussed in detail by keeping all the, in the judgment of this on the report.
If I am right, some Delhi High Court had initiated perjury in a very famous case, after acquitting, because he is a hostile witness,
Oh, yes, hostile witness.
if I am right.
Normally it is. On 161 it is not done, but it also happens.
See, declaring a person as a hostile witness is not a condition precedent for exercising power under section 154.
To cross-examine.
Because
No,
of-
precisely that is the point
Yes.
which I want to highlight.
Ram. We have declared.
Because every time they
We
pass
are
an
not
order.
hostile towards the settled principle of law.
Basically,
No, but then this court right from Privy Council has been using the word hostile witnesses.
That's hostile.
Hostile has been used right from Privy Council. It is not as if that only the magistrates use it.
no, my lord. In case you will, the magistrate is of that point of view, that is naturally on the basis of the statement granted by the, even the police, he should be immediately declared as a hostile. What is his position in the society? He is been to even treated as a
Who will come to the court?
Maybe to that extent he is right. He is treated as something like a, outcast.
Suppose, my lord, I am standing in the bus stand, I see an accident. What is actually? But I am summoned to the court, I come and give the evidence.
What is the evidence?
By a judicial pronouncement, you declare hostile. When I return, you say that you are an unfavorable person. Go back.
No, you have missed.
Who will come to the court here to give you evidence?
And see, in fact, once you accept the position
Yes.
that despite declaration of hostility, the portion of the evidence can be relied upon, that is the law right down. Once the portion of the evidence can be relied upon, that means no stigma is attached. If stigma is attached, the courts will not be relying upon any part of his statement. We continue to rely upon we ultimately the court analyzes the evidence and relies upon it. Once the court relies upon it, where is the question of you declared me hostile? I have become an untouchable in society. Now, How can this contradiction be?
And there can be cases of both the types. At times, the prosecution may, go on recording the statements, similar statements of so many witnesses. There are also times when the witnesses are win over.
No.
Yesterday, I had a criminal case wherein there was a dying declaration of the mother who was deceased. The daughter was witness there. But then at the time, stage of trial, after 3 years, then she was residing with father and she did not support the prosecution case.
You are aware of Uday Kumar case, Annamalai University. His father came. Now let any advocate answer this question. His father cremated the dead body of his son. In court, he was put under pressure. He turned hostile and said, "He is not my son."
That is
Is it what?
So that will depend on facts of each case.
The system, we can't.
Therefore,
You please find a system which is free from all these infirmity.
Therefore, now, what is wrong in declaring that father as hostile?
What we say is, don't declare him as hostile and allow him to be cross-examined.
If a witness this is what you can do to the witness, sir. Both sides, sir. What police is capable of doing. Now the defense is more capable of doing if they are very powerful. Therefore,
there is a reason why we have got answer to
let us not treat the word hostile as stigmatic to the witness so long as a hostile witness statement can be relied upon by the court.
Respond to this would be one. If he is a hostile witness, the implication is this. Hostile is not dealt with in Evidence Act. We draw this word only for English law. As per English law, if a witness is.
But now that is clarified by this judgment. This judgment to which you are relied.
Yes.
It itself says that.
Judgment say, don't declare him as hostile. Allow you to cross-examine. Then take any part of his evidence as a trustworthy. That is what paragraph 52 says. Paragraph 52 does not say that the witness should be treated as hostile. After being declared as hostile, his witness can be believed. It doesn't say so. Paragraph 52 says, allow you to cross-examine. No question of hostility, no question of declaring him hostile. Take any part of the evidence after a cross-examination by the prosecutor.
All right, please proceed, Nagaman.
Yes,
Please
Madam.
proceed.
Now, Murad, that is my humble submission. My submission would be, Murad, in response to Honorable Justice Ramasubramanian. My response is this. If a witness is treated as hostile, the legal implication is that that witness can only be cross-examined, not contradicted. If you are drawing the English principle, if the witness is declared as unfavorable, then only he can be contradicted.
So Nagmatu, even this judgment says that it is preferable not to. Doesn't say that it cannot be done. It cannot be declared as hostile. Again, come to page 742. Therefore, in the order granting such permission, it is preferable.
Yes, Murad. If you prefer to use the word hostile, allow him to be cross-examined only.
This court doesn't say that it is not permissible to use the word hostile.
But what I say is, not preferable. But I think that it is only
It's only a matter of practice which is followed by courts for ages.
But preferable, I fully agree, Murad. If the court prefers to use the word hostile, then the implication is that the witness can only be cross-examined, not contradicted. If he is declared as unfavorable, he can be contradicted.
That distinction has been found not to be correct by the court in the para 52 itself.
52, Your Honor, kindly see, the term hostile is not used. Your Honor, kindly see 50.
52 is an answer.
From
52 is an answer to 41. 41 says that once a witness is done hostile, his evidence cannot be read at all.
For my settlement, let me read 52 minutes. Even in a criminal prosecution, when a witness is cross-examined, that is all. Uncontradicted, that is all. That these two terms of cross-examination and contradiction are dealt with in section 154. It is permissible under that provision. With the leave of the court, by the party calling him, his evidence cannot, as a matter of law, be treated as washed off and record of the record to altogether. This is strictly as per section 154. Under 154, permission is given to cross-examine and also to contradict. If you declare him as hostile, you cannot allow him to be contradicted.
That position is not accepted in India. What is, if you read the judgment in entirety, this is not a position which we accept.
What is highlighted, I read only piecemeal in the judgment, but I leave to this honorable court.
You have to read the judgment in entirety.
Yes, you have to kindly consider that in its entirety, because I only bring it to the Lordship's notice that there is a judgment saying this. But it's for your Lordship to decide.
All right, please proceed.
But let me go to the main crux of the matter. Your Lordship may kindly come to the compilation of page 1, the referral order. Concerning the Prevention of Corruption Act 1988 arises out of the order dated 28/2019 passed by a two-judge bench of the court, wherein they express certain doubts as to the validity of the position of law as expounded by this court in the case of the Satyanarayana Murthy versus District Inspector of Police, State of Andhra Pradesh, so and so. In that case, the court held that in the absence of primary evidence of the complainant, not this, it's not primary evidence, it's a direct evidence of the complainant, due to his death, inferential deduction in order to sustain a conviction under section 7 and 13(1)(d) and 2 of the Prevention of Corruption Act was impermissible in law. This Satyanarayana Murthy, I will take your Lordship to Satyanarayana Murthy. Then next paragraph, however, the court by order dated 20/2019 highlighted a number of judgments such as Kishan Chand Mangal, then Hazari Lal, then Narsingh Rao. Narsingh Rao is the important judgment, 3 judgments. Narsingh Rao, wherein this court.
That is also from state of AP.
AP. Not from Punjab.
These are two from Punjab.
Then 376 from which state?
I think it has all-round
All
implication.
over India.
All-rounder.
376 is all over India,
All over India.
no exception.
Yes. Paragraph 2 minutes. However, the court by order dated 20, so the judgment Narsingh Rao, wherein this court, despite the absence of primary evidence of the complainant, it can't be primary evidence, it's only wrongly used direct evidence of the complainant, sustained the conviction of the accused by relying on other evidence. Relying on other evidence. This proposition I already submitted. Other evidence means if there is another witness who has seen or documentary evidence, then presumption or circumstantial evidence. And raising a presumption under the statute. Then, noting the divergence in the treatment of the evidentiary requirement for providing the offence under section 7, section 13(1)(d), reduce section 13(2) of the Prevention of Corruption Act, the court referred the following question of law for determination by a larger bench. Question. The question whether in the absence of evidence of the complainant, direct or primary, evidence of demand of illegal gratification, is it not permissible to draw inferential deduction of the culpability of guilt of a public servant under section 7 and section 13(1)(d), reduce section 13(2) of the Prevention of Corruption Act of 1988, based on other evidence adduced by the prosecution? If there is other evidence available, well, it is for the court to appreciate to see whether demand has been proved or not. The question doesn't say that there is no other evidence. If there are other evidences available, then that both without saying much, based on that there can be conviction. Demand can be proved. Then we note that 2-3 judge benches of this court in the case of B. Jayaraj versus State of Andhra Pradesh, P. Satyanarayana Murthy versus District Inspector of Police Andhra Pradesh, these two, Andhra, or in conflict with an earlier three-judge bench of this court in Narsingh Rao versus State of AP, all the three AP, regarding the nature and the quality of proof necessary to sustain a conviction for the offences under section 7 and 13 only, reduce it to 13. Two of them. Therefore, considered appropriate to refer the question of law framed to be decided by the bench of appropriate thing. So this is the reference. Page 5 minutes.
Yes, we have.
The report to Manoj, I have submitted by B. Jayaraj case. You ought to kindly come to paragraph 6. Last 2 lines. EW2, the complainant did not support the prosecution case. He disowned making the complaint accused P11 and he stated in his deposition that the amount of rupees 250 was paid by him to the accused with a request that the same may be deposited at the bank, etc. However, PW1 confidently says, so therefore this is a case where PW1, one of the defect of complaint, did not support the case of the prosecution. He disowned even the complaint.
1 minute.
I will permitted to use the word hostage.
See, some information which we discuss or we are not supposed to disclose.
But it must be a very valid information.
Valid and
Privileged.
privileged communication.
We don't know whether it is valid or not, but it is privileged.
Though we are interested in knowing, we don't have a right to, or the court to disclose.
We are also interested in knowing what you talk about us outside the courts. You will never tell us.
The court,
But of course, Nagapathy, when we were lawyers also, we have also discussed. Don't we?
it is, the court should have this much of humor. The court should have humor like this. Then only it will be alive. Otherwise, rigidly sitting and it is like only talking, somebody will be talking, somebody will be hearing. That may not be the participating procedure that is being followed. The practice may not of having hearing.
That depends on the advocate who is arguing.
All right, please proceed.
Great. But one second, minute, without wasting the time of this on report, 1 minute, G. Ramaswamy, sorry, V.L. Ithran, I'm sorry, this is by G. Ramaswamy. G. Ramaswamy wanted an adjournment in the Madras High Court. His lordship knows it. But he sent his junior to the court. His junior said, he requested for adjournment. Judges were very furious. They said, no adjournment, nothing to do. You have a senior to come. And he came sometime later. On seeing him, judge asked, remarked, what is this, Mr. Ramaswamy? We should argue the matter. No adjournment, no. I come here not for any adjournment. Then you argue the matter. I want only small pass over. Yes, we will pass over till tomorrow.
There are many anecdotes of
Yes,
G. Ramaswamy which we have heard about this court also.
yes, yes.
Some of them cannot be shared.
At least which we cannot share in the courtroom.
Yes, yes.
All right, please proceed.
Yes, but paragraph 8,
Yes.
paragraph 8, you will have to kindly come to paragraph 8. In the present case, the complainant did not support the prosecution case insofar as demand by the accused is concerned. The prosecution has not examined any other witness. You will have to kindly see there was no other witness available. Witness present at the time when money was allegedly handed over to the accused by the complainant to prove that the same was pursuant to any demand made by the accused. When the complainant himself had disowned what he had stated in the initial complaint exhibit P11 before LW9, and there is no other evidence to prove, no other evidence, you will have to kindly consider this also, there is no other evidence to prove that the accused had made any demand, the evidence of PW1 and the contents of exhibit P11 cannot be relied upon to come to the conclusion that the above material furnishes proof of demand allegedly made by the accused. We are therefore inclined to hold. The High Court was holding that demand alleged to be made by the accused as proved. The only other material available is the recovery of the tainted currency notes from the possession of the accused. In fact, such possession is admitted by the accused himself. Mere possession and recovery of the currency demand will not bring home the offence under section 7. Well, this is a correct proposition. Demand, I already submitted, demand is to be proved as a fact in issue. It can be done by 4 methods, I have said. But the judgment also says the same thing. It says that there is no other oral evidence available to prove the demand, no documentary evidence, no legal presumption is available, no circumstantial evidence that the demand has not been proved. When the demand is not proved, mere recovery or mere possession of the tainted currency notes in the hands of the accused would not give rise to any presumption that it was accepted in terms of section 7 or obtained in terms of section 13 only. Because they require prior demand. Demand may be by the public servant or maybe by the non-public servant, by the bribe giver. Demand is to be there. When the demand is not proved as an ingredient of obtainment or as an ingredient of acceptance in terms of section 7, then there can't be a presumption that it is a bribe money. That is what is said. This judgment clearly holds the modes or method by which the demand can be proved. This judgment is absolutely correct. Then you will have to kindly come.
No, he says, when the complainant himself disowned what he had stated
Yes.
in the complaint,
Yes.
was it treated as a hostel or something here? In this case, no, we don't have anything. And whether his statement, whatever is available in the chief's examination has been considered, we don't know.
Yes, yes, yes.
So he was
But he has said in the chief examination that I did not give it as a bribe. I gave it to him with a request to him to deposit in my account.
In the cross-examination, what has he said by the prosecution himself under 154?
And he withstood what he said in the chief examination.
But there is nothing here.
Nothing could be elicited.
PW1 Parasi did not support the prosecution case. He disowned making a complaint. This was even making the complaint. Parasi.
No evidence.
And that stated in is fully hostile.
Fully on facts.
Fully hostile.
Fully hostile. Total hostility.
Total hostility.
Yes.
All right. Next.
That the
But
judgment
one
may
thing,
not-
my lord,
Rahamuthu, the judgment may
what
not-
PRF,
the judgment may not be correct. He doesn't mere possession of currency notes from the accused without proof of demand. But the problem is he is obliged to explain why this currency was with him. Section 114.
106,
106.
Yes.
106 of the evidence.
He has to explain how a government servant sitting in his office.
But he will explain. that explanation is there in this case, one of the judgment is correct because the explanation is that he gave it to me only for the purpose of depositing the same in his account. It is there. That explanation is accepted. Key to that explanation, there is no evidence. To discard that explanation.
Here in the case, the complainant himself stated that he had given that amount of rupees 250 to be paid by the accused with a request that the same may be deposited with the bank.
This is my defense.
No. This is the complainant's case, so therefore you need not plead
Yes,
your
yes,
defense.
that's what I said. But the explanation of the accused is this, that is supported by the evidence of the complainant, that is accepted by the court because there is no contra evidence. No contra evidence.
See, once this complainant's evidence is accepted,
Yes,
that means the court believed him to be true.
yes.
What is the effect of declaring him hostile earlier?
But
If your logic is right.
Brother, they have to take the credit that I don't believe you, that is all.
Therefore, it did not attach any stigma.
All right, yes.
Brother, the next judgment is Satyanarayana Murthy that has been referred to in the referral order. That your lordship will find at page 10, page 10. Brother, this is by 3-judge bench again. Your lordship may kindly come to paragraph 4. Page 13, paragraph 4.
Yes, we have.
On completion of the investigation, charge sheet was filed against the appellant. Thereafter, the charges under section 7 and 13(1)(d), reduced section 13(2) of the Act were framed against him, of which he pleaded not guilty. At the trial, the prosecution examined 7 witnesses and also adduced documentary evidence in support of the charges. As the complainant, Jagan Mohan Reddy, had expired prior thereto, he could not be examined by the prosecution.
Good people, I mean.
Paragraph 4, fourth line.
Yes.
At the trial, the prosecution examined 7 witnesses and also adduced documentary evidence support the charges. As the complainant is Jagan Mohan Reddy had expired prior thereto, he could not be examined. But Jayaraj case, he turns off it. He can't support. Here he died. Now,
Yes.
let me kindly come to paragraph 13 at page 14. Page 14. Paragraph 13. Admittedly, paragraph 13. Admittedly, the complainant is Jagan Mohan Reddy, the then principal of so and so institute, could not be examined as a witness for the prosecution as he had expired before the trial. To reiterate, in his complaint lodged with the Deputy Superintendent of Police Anti-Corruption Bureau, Kurnool, on 3/10/1996, he alleged that on the same day, the appellant who was then the Assistant Director Commissioner of so and so had visited his institute and he had pointed out that because of his omission, etc., demand was made, complaint. But complaint cannot be used as substantive evidence, but it is only a formal statement which could be used either for corroboration or for contradiction, therefore this was discarded. Now your lordship may kindly come to paragraph 9, on page 13. B. Jayaraj is referred to. The Honorable Senior Counsel for the appellant to buttress his contention placed reliance on decision of this court in V. Jayaraj, the earlier case, my lords. Then paragraph 20. They refer to criminal misconduct by public servant, etc. my lord. Paragraph page section 13 is invoked, extracted. Then this court in Sabir, but the state of Kerala will delving on the purport of the statutory prescription section 713 of the Act. The prosecution has to prove the charge thereunder beyond reasonable doubt, like any other criminal offence, and that the accused should be considered to be innocent till it is established otherwise by proper proof of demand and acceptance of illegal gratifications, which are vital ingredients necessary to be proved to record a conviction. So demand is to be proved. Then receipt is to be proved, not acceptance, receipt is to be proved. Demand and receipt make out either obtainment or acceptance, depending upon who made the offer. So here, the language should have been, what should have been used is demand and receipt, not acceptance. Acceptance has got a specific meaning assigned in section 7. So demand and receipt of illegal gratification, which are vital ingredients. Then, paragraph 22 at page 17, several judgments are reported in the meanwhile. Paragraph 22, in a recent enunciation by this court to discern the imperative prerequisites of section 7 and 13 of the Act, it has been underlined in V. Jayaraj in unequivocal terms that mere possession and recovery of currency note from an accused without proof of demand would not establish an offence under section 7 as well as section 13(1)(d) of the Act. It has been propounded that in the absence of any proof of demand for illegal gratification, the use of corrupt or illegal means or abuse of position as a public servant to obtain any valuable thing or pecuniary advantage cannot be held to be proved. The proof of demand thus has been held to be an indispensable essentiality and permeating mandate for an offence under section 7 and 13 of the Act, plus section 20 of the Act, which permits the presumption as envisaged therein. It has been held that while it is extendable only to an offence under section 7, this also during my earlier argument is submitted. Section 20 is applicable only to 7, not to section 13(1)(d). It is upheld here. It has been held that while it is extendable only to an offence under section 7 and not to those under section 13(1)(d) of the Act, it is contingent as well as on the proof of acceptance of illegal gratification for doing or forbearing to do any official act. Such proof of acceptance of illegal gratification, it was emphasized, could follow only if there was proof of demand. Axiomatically, it was held that in the absence of proof of demand, such legal presumption under section 20 of the Act would also not arise. So, if demand is not proved, then even 20 presumption would not arise. I report to section 20, madam.
Yeah, it better. Do that.
Minutes, not the amended one, the old one. At the bottom it is given.
Subsection 1.
Yes. May I read it, madam?
Yes.
Presumption where public servant accepts gratification other than legal remuneration. The title itself is this. Presumption where public servant accepts gratification other than legal remuneration, not obtains. Obtains is the term not traceable to section 13(1)(d). Where in any trial of an offence punishable under section 7 or section 11 or clause A or clause B of subsection 1 of section 13(1). 13(1)(d) is missing. It is proved that an accused person has accepted or obtained or has agreed to accept or attempt to obtain for himself or any other person any gratification or any valuable thing from any person, it shall be presumed, unless the contrary is proved, that he accepted or obtained or agreed to accept or attempt to obtain that gratification or that valuable thing, as the case may be, as a motive or reward. So this is the only presumption. But even for this, demand is to be proved. I have already highlighted. Section 13 only speaks of obtainment alone. Obtainment has got two ingredients. One is offer, that is demand. The other one is receipt. Similarly, in the case of acceptance, I dealt with in section 7 also. There is an offer by the bribe giver. Please, I'll give you 50,000 rupees, do this. There is a demand that if this should be done, I'll give 50,000 rupees. There also there is demand. It is accepted by the public servant. So offer emanates from the public servant. It is accepted by the bribe giver, that is obtainment. Offer emanates from the bribe giver. It is accepted by the public servant. It is acceptance. Both are different. Number in both the cases there is demand. There are two ingredients. One offer, the other one is acceptance. That is what is dealt with in section 20. That's the only term used. Obtainment. Obtainment, I got a judgment to cite also, I am citing. Obtainment means, there has to be an offer by the public servant, which is otherwise known as demand. That I will clear your file, you pay me 50,000 rupees. This is the offer made by the public servant, demand made by the public servant. When the bribe giver accepts this offer, he comes and pays it. So he receives. This is obtainment. By means of a demand, he receives it. This is obtainment. Whereas, so far acceptance, which is used in section 7 is concerned, public servant never demands.
He is a very good man. He simply accepts whatever is given to him, does not make a demand. Therefore, he is not covered by PC Act. Correct?
No.
He is covered by section 7. I don't say that he is innocent.
No, but we were just wondering, what is the research we are doing on offer, acceptance, demand, obtainment? Why are we doing all this research? People who take money for doing something should escape.
No, to liberate those people who have been falsely implicated.
No, but in the
money, you know, currency is caught.
No. Prima facie, Mr. Nagmathu. In the present case,
Yes.
if you read the evidence of PW1,
Yes.
and if such evidence is also discarded, then it will be frustrating the very purpose of the enactment.
Yes.
A person is a witness who is a public servant.
Yeah.
He goes along with the accused.
Yes.
The accused asks him whether you have brought the money. He said, I have brought the money and also the application.
Yes.
He hands over the application to him. He accepts the money.
Yes.
The trap is laid.
Yes.
In the trap, he is found with that money. And thereafter, his evidence is disputed because there is no demand.
Well, that,
So,
whether to bring
he specifically asked whether you have brought the money. That money is for what? A wedding gift or
my humble submission to you, Mullards, whether the
So let us see how the evidence of PW1 is discarded.
that is on
Para
fact.
24.
That is on facts. So it falls within the domain of appreciation.
Yes. Therefore, even in the absence of the complainant's evidence,
Evidence.
you rightly said that the evidence of other witnesses can be taken into consideration. on facts prima facie, I am of the view that this judgment doesn't lay down a correct
No,
proposition.
no.
Because PW1
No, no, proposition of law is right, but in this case, with great respect, I am submitting. In this case, the proposition, what is the proposition of law? In the absence of proof of demand, by means of mere recovery, one cannot be convicted. That is the proposition of law. That is too well settled, that cannot be doubted. But in this given case, whether from other evidences, demand has been proved or not, falls within the domain of appreciation in the given set of facts.
Of course. So therefore, even if the complainant is turned hostile or is dead, from the evidence of the other witnesses or attending circumstances,
Demand can be proved.
demand can be proved.
That is what Murari is my submission from the day one. I fully agree with this proposition.
Because in the present case, prima facie, I find that from the evidence of PW1, it was.
In the case, Murad, what is the law laid down, what is proposition which is reiterated is that demand as a fact in issue is to be proved. Murad, what is the fact in issue, Murad? Let us go to the evidence action of foreign movement. You have to kindly consider that evidence action. What is the fact in issue?
Means even in the absence of direct evidence,
Fact in issue. Evidences, any disputed fact can be proved. Rashi was also jocularly asking whether you are asking. I stated the law correctly that any disputed fact, any fact in issue can be proved by any evidence. I said 4 modes: direct witness evidence, eyewitness account, 59 and 60 of the Evidence Act, documentary evidence, 62, 63 and 65 of the Evidence Act, then legal presumption under section 114 of the Evidence Act. Lastly, based on circumstantial evidence. That is again an inference under section 114 of the Evidence Act. So, in the given case, though the de facto complainant is dead, the next examination is whether there is any other evidence available. If there is some evidence, I gave an illustration also. Suppose when the demand is made, his friend is sitting by the side. He comes to the court and says, yes, I was there when the demand was made. This is what he demanded. But if his evidence is believed, demand stands proved. So it is not depending only, in my case, factually I say that the only evidence which was available on record was that of the evidence which spoken by the de facto complainant. There is no other bystander to speak about that. There is no documentary evidence. There is no legal presumption available. There is no foundational facts. There is no other circumstantial evidence available, unerringly to point to the guilt of the accused. Nothing is available. Therefore, in my case, the prosecution relied only upon the proposed evidence of the de facto complaint. He is no more. That was my submission in my case. Therefore, you ought to kindly have a look at
Dead or turns hostile.
turns hostile, which means there is no evidence to prove the demand. That is not, you ought to kindly consider that it may be totally eschewed. Or you ought to also hold that this evidence is not sufficient. There are 2 things in the matter of appreciation of evidence. One may say that this evidence is inadmissible. Then thereafter there is no further inquiry. If the court holds no, it is admissible, the next inquiry would be whether it is credible or believable. Now, if you Lordship may at that say that no, it is not believable, no more inquiry. If you Lordship holds yes, he is believable, then comes the next question, whether this part of the evidence is sufficient or not. That is the next stage. Then against whom it is going to be used. Stage by stage, step by step, the evidence is to be appreciated. All fall within the domain of appreciation of evidence, which differs from case to case. Now, now we are dealing with the legal proposition. Can there be conviction in the absence of proof of demand? No.
Muthu, you have not added one sentence. Appreciate step by step, give him benefit of doubt.
Yes.
You did not add that sentence.
Right?
Because it is criminal law. Don't use preponderance of probabilities. You did not say this.
Yes, yes. But old Milton principle. But Your Honor, kindly look at this definition alone for a moment. Facts and issue, Murat, section 3 of the Evidence Act. Facts and issue. The expression facts and issue means, I think Your Honor, you have to.
Yes.
The expression facts and issue means and includes any fact from which either by itself or in connection with other facts, the existence, non-existence, nature or extent of any right, liability or disability asserted or denied in any suit or proceeding necessarily follows. The explanation. Whenever under the provisions of the law or the timing in force relating to civil procedures, any court records an issue of fact, the fact to be asserted or denied in the answer to such issue is a fact and issue in civil law. In criminal law, Your Honor, kindly go to the illustration. A is accused of murder of B. At this trial, the following facts may be in issue. Number 1, that A caused B's death. Number 2, that A intended to cause B's death. C, A had received grave and sudden provocation. B, that A at the time of doing the act which caused B's death was by reason of unsound of mind, incapable of knowing its nature. So these are all the some illustrations, not of facts and issue. So in case of obtainment, there are 2 facts and issue. Number 1, he demand, whether there was demand. Fact number 2, fact and issue number 2, whether he received the money in pursuance of the demand. Similarly, in the case of acceptance, there are two facts and issue. Every fact and issue is to be proved beyond reasonable doubt. It can be done, either way. So therefore, so far as this case is concerned, this Satyanarayana Murthy is concerned, my humble submission would be, the law has been correctly laid down. In Satyanarayana Murthy,
Because he is Satyanarayana.
on both, where Satya means both.
And the word primary
Yes.
is used in Satyanarayan, therefore it is found in reference.
That is wrong.
But then,
That is inappropriate.
that credit now should not go to the referral order. That goes to Satyanarayana.
But the use of the,
No, in English law, for direct evidence, they say primary. In English law.
But
English
here,
evidence-
the evidence act distinguish between these two.
Yes, yes.
Oral evidence means it must be direct as per section 59.
Here we say direct and indirect.
Indirect.
Direct and hearsay.
Direct means hearsay.
Hearsay. But in English law, they say primary.
The primary evidence means it is.
For oral evidence, they say.
Primary evidence refers only to document.
We say it for documents. But in English law, they say primary evidence for direct.
So therefore, so far as Satyanarayana is concerned, the use of the word primary evidence, although it is traceable to oral evidence, may not be appropriate. But what they mean, their lordships mean is not direct evidence.
Direct.
In terms of section 59 of the Evidence Act. Now, when there is,
The real question would be in the absence of the evidence of if the complainant is dead or is turns hostile, whether the demand can be proved by other evidence or not.
yes, it can be.
It can be, yes.
I can say, that was my first argument. It can be. I said-
Then Satyanarayana appears to have been wrongly decided because it's totally, so the complainant is not there.
Yes,
But then that PW wants evidence.
yes,
If it is taken into consideration,
yes.
that would have been sufficient to prove their demand as well as
What
acceptance.
on, we do not have the entire evidence. Both on reading the entire evidence, on appreciating it, come to the conclusion
No.
that this is not sufficient.
No, so therefore, prima facie, we find that the reference is correct because Satyanarayana, in spite of there being evidence
Yes.
and in spite of there being presumption,
Yes.
there is no evidence as to how the presumption is, how.
But one may differ in the matter of appreciation, not the law stated. Satyanarayana never said that the factum of demand cannot be proved by means of other evidences in the absence of the defect of complaint. Never it said. It is rightly held that even in the absence of the evidence of the defect of complainant, the factum of demand can be proved by means of other evidences. Rightly held. But in the matter of appreciation, but we do not, at this length of time, we do not have the evidence. What are the material before their lordship? We do not have. Now, their lordships on appreciating the entire evidence has come to the conclusion that the evidence of the punch witness is not sufficient to prove the demand. Right? It falls within the domain of appreciation. Therefore, Murad, without having the evidence before us, without having the entire record before us, Murad, I don't think, Murad, that we will be in a position to say that that appreciation is wrong.
In any case, we can't go on that because we
Yes.
can't, we are not sitting in an appeal.
Yes.
We only have to answer the reference.
Yes, but law stated in that judgment is right. As my lord agrees with me. What is the law stated? The demand as a fact and issue is to be proved beyond reasonable doubt. How it is to be proved? In the absence of defect or complaint from other evidences. That is agreed.
Acceptance.
Can be raised.
No presumption, no proof,
No proof.
nothing. If there is other evidences, it's all right. But presumption would not arise. Section 20 cannot be invoked. To invoke section 114 Murat of the Evidence Act, I have already submitted. Foundational facts are to be proved. Some foundations. I gave the illustration of the case of theft. Murat, let us take the case of dowry demand, dowry death. Murat, foundational facts are there has to be marriage and death should occur within 7 years. And soon there should have been demand or harassment in connection with the marriage. Soon before the death. These are all the foundational facts. If these facts are proved, then from out of that, what will presume that the husband or the relative has caused the death. In the absence of proof of any one of these foundational facts, 114 presumption cannot be raised. Similarly, in this case also, Murad, 114 is applicable to Prevention of Corruption Act as well. There is no exclusion. But the foundational fact must be proved in order to invoke the presumption section 114. Now, in this case, in Satyanarayana, because there was no evidence, foundational fact proved to raise a presumption section 114, no documentary evidence, and except the punch witness, no other evidence. That evidence was found to be insufficient by the court. It is on evidence. The law stated in Satyanarayana Murthy is absolutely correct, is my very respectful submission. Then, paragraph 25 and 26 also says the same thing. Paragraph 25, you ought to kindly come to.
In our estimate.
Yes, in our estimate, to hold on the basis of the evidence and record that the culpability of the appellant under section 713D has been proved would be an inferential deduction which is impermissible in law. So mere inferential deduction without there being foundational facts, is impermissible. This is the correct position of law. This is doubted. In the referral order, paragraph 25 is doubted. Not doubted, they say that this is contrary to Narsingh Rao. My humble submission is this is a correct statement of law. There can't be, in the absence of the proof of any foundational fact, it cannot be, there cannot be an inference, there cannot be a presumption under section 114. Paragraph 26, in reiteration of the golden principle which runs through the web of administration of justice in criminal cases, this court in Sujit Biswas, state of Assam, had held that suspicion, however grave, cannot make the place of proof and the prosecution cannot afford to rest its case in realm of may be true, but has to upgrade it in the domain of must be true in order to steer clear of any possible surmise or conjecture. It was held that the court must ensure that miscarriage of justice is avoided, and if in the facts and circumstances of two views are plausible, then the benefit of doubt must be given to the accused. My lord was pleased to ask us, what is the endeavor of this bench? The endeavor of this bench is this, that the court must ensure that miscarriage of justice is avoided. This is the endeavor of this bench.
Miscarriage or carriage? See, in fact, it is only in such cases we do more research. I think all these distinctions, the persons who take bribe are very well aware of. Only the courts which have not correctly understood.
Oh, always, Murad, the criminals are far more intelligent than the police.
That's right. And the court.
Yes. What I don't say that.
All right.
But then you ask me kindly, Murad, these two judgments are three judge benches.
Yes.
These two judgments have been reported in the referral orders. But in these two judgments, in my humble submission, law has been rightly stated. Then you ask me kindly consider the next one, Narsingh Rao, page
Narsingh Rao.
19. This is stated to be a conflicting judgment.
Hmm.
But there is no conflict, it is my humble submission. This also states the law correctly. But Narsingh Rao, 2001, 1 SCC, page 691. Compilation, page 19. The top note I have given the number.
Clearly saying this witness.
Inner page 695, paragraph 5.
Paragraph 5.
Yes. Paragraph 5, middle minutes, page 695. Both the witnesses were declared hostile by the public prosecutor.
No, paragraph 5 is
Page 695, page 695, not of the inner page of judgment. Not my page is page
Both
23.
witnesses, yes.
Not the paragraph, page 23 of my compilation, page 23 of my compilation. 6 lines from the top.
Yes.
Yes. Both the witnesses were declared hostile by the public prosecutor and both were cross-examined in detail. After examining the remaining witnesses for the prosecution, the appellant was called upon to answer the question put him under section 313. So the vital witness, there were two witnesses to speak about the demand. Not only the complaint, another accompanying witness as well. Both turned hostile. Now what is the position now? You ought to kindly see paragraph 8, my lord. Paragraph 8. It is at page 23. Mr. L. Nageshwar Rao, the Learned Counsel for the appellant, adopted a twin contention. First is that the presumption under section 20 of the Act could be drawn only when the prosecution succeeded in establishing with the direct evidence that the delinquent public servant accepted or obtained, not two things are there, accepted or obtained gratification. That premise cannot depend on an inference for afford foundation for the legal presumption envisaged in section 20 of the Act, according to Learned Counsel. The second limb of this contention is that it is not enough that some currency notes were handed over to the public servant to make it acceptance of gratification. Prosecution has a further duty to prove that what was paid amounted to gratification contended the counsel. Not paragraph 9, in support of the first contention, the Learned Counsel relied on the decision of two judgments of this court in Sitaram, state of Rajasthan, where it was held. Then so many judgments are referred to. Then you will also kindly come to paragraph 14. Paragraph 12.
Brother,
Paragraph 12.
you can't claim immunity. It's also found of Sitaram.
Paragraph 12 at page 24.
Yes.
Section 20 is extracted.
Yes.
Then in paragraph 13, before proceeding further, we may point out that the expression may presume and shall presume are defined in section 4 of the Evidence Act. This on the first day of my argument, I highlighted the difference between may presume and shall presume. Same thing, are defined in section 4 of the Evidence Act. The presumptions falling under the former category are conveniently known as factual presumptions or discretionary presumptions, and those falling under the latter as legal presumptions or compulsory presumptions. When the expression shall be presumed is employed in section 21 of the Act, it must have the same import of compulsion. Then paragraph 15, let me kindly skip paragraph 14 minutes. let me kindly come to paragraph 15. The word proof need be understood in the sense in which it is defined in the Evidence Act, because proof depends upon the admissibility of the evidence. A fact is said to be proved when, after consideration on considering the matters before it, not evidence before the court, matters before the court. The court either believes it exists or considers its existence so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that it exists. This is the definition given for the word proved in the Evidence Act. What is required is production of such materials on which the court can reasonably act to reach this supposition that a fact exists. Proof of the fact depends upon the degree of probability of its having been existed. But I do not want to waste my the time of this honorable court by explaining as to what are the matters, how there are two parts in section 3 proved. That is, when the court believes the existence of the fact. Second part, when a prudent man supposes, and which is supposition is probable. If you lordship permit me, I will explain, otherwise I will skip minutes.
No, you proceed.
Yes, then, when you lodge me, come to paragraph 17, presumption. What is presumption? Is dealt with. In paragraph 18 and 19, 18, for the purpose of reaching one conclusion, the court can only rely on factual presumption. Unless the presumption is disproved or dispelled or rebutted, the court can treat the presumption as not amounting to proof. However, the caution of prudence we have to observe that it may be unsafe to use the presumption of draw yet another discretionary presumption unless there is a statutory compulsion. Then, in paragraph 19, they refer to section 114 presumption. Paragraph 19. Illustration A to section 114 of the Evidence Act says that the court may presume that a man who is in possession of stolen goods soon after the theft is either the thief or has received the goods knowing them to be stolen unless he can account for his possession. That illustration can profitably be used in the present context as well as when the prosecution brought reliable materials that apparent's pocket contained phenolphthalein smeared currency notes of rupees 500 when he was searched by PW7 DSP Anti-Corruption Bureau. That by itself, the law is correctly stated here also by this court. That by itself may not or need not necessarily lead to a presumption that he accepted that amount from somebody else, because there is a possibility of somebody else either stuffing those currency notes into his pocket or stealthily inserting the same therein. But the other circumstances which have been proved in this case, and those preceding and succeeding the searching out of the tainted currency notes, are relevant and useful to help the court to draw a factual presumption that the appellant had willingly received the currency notes. This is again, law is stated correctly. In a given case from other circumstances, can it be presumed that he received it as an illegal gratification? It's a question of fact again. But law has been rightly stated in paragraph 19 that that by itself may not or need not necessarily lead to a presumption. Then from the paragraph 21, from those proved facts, the court can legitimately draw a presumption that the appellant received or accepted that currency note on his own volition. What is the presumption? Money is in the hands of the public servant. What is the presumption under section 114? He has received it. That is all. Whether he received it, whether this received amounts of obtainment or it amounts to acceptance requires proof of demand. So mere receipt is not enough. Under section 114, there can only be a presumption that he received it because he keeps it. The presumption can be yes, he received it. That is all.
But what about presumption under section 20?
20 presumption is limited. It speaks only of reward or motive. That is all. Provided, as held in Satyanarayana Murthy, provided demand is proved. When demand is proved, then it amounts to obtainment. When obtainment is proved, then presumption under section 20 will come. That is under section 7.
But it doesn't restrict. it shall be presumed unless the contrary is proved
Yes,
that he accepted or obtained or agreed to accept
yes, yes,
or attempted to obtain
Yeah.
their gratification
yes,
or that valuable thing,
yes.
as the case may be, as a motive
Or reward.
or
that is the
reward,
presumption.
such as is mentioned in section 7,
Yes,
or as the case may be,
yes, my lord. No, there is,
with consideration or for consideration which he knows to be inadequate.
yes, my lord. My lord, what he presumed? He received it, what for? As a reward or motive, that is all. But he doesn't prove the demand. He doesn't prove the acceptance. But acceptance requires not an offer and acceptance, offer and receipt. But a receipt alone is proved. Not demand is not proved. Unless demand is, that is why
Then,
Satyanarayana.
section 20 will have to be held to be redundant because
No,
section
it will
20.
not, it will not become redundant in my humble submission. Reason is, in a case where, suppose in a given case, complainant speaks about the demand. He speaks about the receipt. He gives it, he receives it. The entire thing is proved. Then, there is no evidence as to what for it is received. To that extent, there can be a presumption. What is the presumption? Yes, he demanded or he accepted the amount only as a motive or reward. That is relevant for section 7. For section 13(1)(d), section 20 is not applicable. It is excluded in section 20. You have to kindly look
Yes,
at it.
13(1)(d) is not there.
Yes, 31(d) is not there. Section 7 alone is there. So when section 7 to invoke section 20, these foundational facts are to be proved. If that is proved, what do you presume? It is not presumption of guilt. It is only the presumption is that yes, he received what for? As a motive or reward. That is the only presumption. There is no presumption of guilt at all.
See, that becomes a little incongruous. The reason is receipt is proved.
Yes.
A presumption is raised under section 20 that it was received as a motive or reward.
Reward, yes.
But demand is not proved.
Yes.
So take this case. Demand not proved. Receipt is proved.
Yes.
A presumption is raised that this receipt is as a motive or reward.
Yes.
No conviction?
Not that my submission is you cannot invoke the presumption at all. Reason is, precondition is mere receipt would not give right to the presumption. It is proof of demand and acceptance, proof of obtainment. Proof of acceptance in terms of section 7 or proof of obtainment in terms of section 7 alone give rise to presumption. It is not mere receipt. Two things are to be proved. There were demand,
So
there was receipt.
person has accepted or obtained. The words used are
Accepted or obtained. Yes, Murad. Obtainment principle.
So you agree that at least for the purpose of section 7 it will be sufficient.
Section 7, Murad, acceptance or obtainment. Acceptance has got two ingredients. That is one, Murad, there is an offer, there is an acceptance. Murad, so far as obtainment is concerned, there also there is an offer, there is an acceptance. From whom it emanates? In the case of obtainment,
That you already argued it should start
that
from
is-
the
so,
public servant.
Narayanamurthy clearly says that this presumption of section 20 can be raised only if the demand and the receipt are proved. Otherwise, the section 20 cannot be invoked. That is Satyanarayana
For-
Here also,
For 13(1)(d).
for section 7. For section 7, Murad.
For section 7 also.
7 also. Murad, section 20 is not applicable to 13(1)(d) at all. Did I receive? Whether I demanded and received, or he offered and I received. These are all the facts which cannot be presumed. These facts are to be proved independently by the prosecution.
That is for the person to explain.
But I will explain. But I explain. This is my pen. I keep it in my pocket. There ends the matter. It is for the prosecution to say no. This you demanded from him and received it as gratification. That is why it is in your pocket. This fact cannot be presumed. It is to be proved as a fact and issue. Not under 114, the limited presumption is.
No, suppose if acceptance is proved,
Yes,
there is a Pancha witness
yes.
who states that trap was let down and then after receiving the signal, we came and the accused accepted the money.
Yes.
There is an immediate search.
Not accepted, received the money.
Received always.
He received.
Okay, received.
He gave it, he received. Not acceptance, Murad, is a legal term used in section 7. Murad, acceptance means, Murad, both offer and receipt. Murad, in case of obtainment, demand and receipt. Receipt is different from acceptance. Acceptance is a legal term used in section 7. That mere receipt, that is why, Murad, it has been consistently held. Mere receipt of any money or property would not prove demand. Mere receipt would not give rise to any presumption that it was that there was obtainment, there was acceptance. Acceptance and receipt are different. Acceptance is a legal term used in section 7, whereas accept is a term referring to the factum of receiving. He gives, he receives.
And also, but the other circumstances which have been proved in this case and those preceding and succeeding the searching out of the tainted currency notes.
That is the correct position of law. From out of the other circumstances, if demand could be proved, I am keeping it, there is a presumption that I received it, both go together to prove either acceptance or demand, then you can raise the presumption of section 20. From other evidences or from other circumstances, the demand is to be proved.
See, why should there be a presumption at all? Once demand is proved,
Yes,
receipt is proved.
yes.
Where is the see, along with the demand, automatically goes the fact that it was demanded for as a motive or reward. There need not be a presumption at all separately. Once demand is proved, accept receipt is proved. Where is the question of presumption? Why you
There may be a case where, Murad, what for the money was, suppose, Murad, in a given case, there is no evidence to even, direct evidence not to speak about the motive or reward. But motive or reward, you have to kindly see in 13(1)(d), what for the money was received, whether it is a motive or reward is irrelevant. 13(1)(d) does not cover this. You have to kindly see. The term motive or reward is used only in section 7, not there. That is the reason why section 20 has been made applicable to section 7 alone, not to 13(1)(d). So, for the purpose of section 7, the distinction is this. For the purpose of section 7, it should also be proved as a question of fact that the money was received as a motive or reward. It is to be proved. Whereas, Murad, in section 13(1)(d), there is no such ingredient. 13(1)(d), you have to kindly consider 13(1)(d), motive or reward. Accepts or obtained or agrees to accept or attempts to obtain from any person for himself or for any other person any gratification whatsoever other than legal remuneration as a motive or reward. But this includes even a non-public servant. But I can make a demand for myself. I can make a demand for my superior. But motive or regard for that man is to be presumed because he has not made any demand. But my superior has not made any demand. It may be between me and him. So therefore, Murar section 20 says that you presume that this is received or it is obtained as a motive or reward. Section 7 alone uses the word motive or reward as an ingredient. 13 only does not say that.
But this court in Narsingh Rao
Yes,
also relies on the earlier judgment of Justice Krishna Iyer,
yes, Murar.
which holds that the very fact of an assistant station master being in possession of the marked currency
Yes,
notes against
yes.
Receipts of it.
Murat, my humble submission would be Murat. Though the
Your-
judgment, Murat,
para-
my humble submission.
para 22.
I thought it is a very great respect, Murat, my humble submission would be. In Sukhbir Murat, Honorable Justice V.R. Krishna here has applied the doctrine of receipts or lacutor. Murat, too well settled, I can cite at least 1,000 judgments to say, Murat, that this doctrine is essentially applicable only to law of torts. Murat, it is excluded. So far criminal jurisprudence in India is concerned. Not only here, even in English law. It is too well settled. I am citing judgments for that. But I expected this question from your lordship. So Sukhbir, I in my compilation I filed that his lordship says that by applying the doctrine of receipts or acquitter, you can presume that it was the factum of demand is proved because I keep the money, I receive, I keep by means of receipts or acquitter. It can be presumed that there was demand. That is a state judgment, only one judgment. But to my knowledge, I have made a thorough research. All the judgments will go together to say that the principle of receipts or acquitter is applicable only to law of torts, and this has got no role at all to play in criminal jurisprudence. Suppose there is a car going. Car goes off the road, dashes against the tree. Applying the doctrine in the motor accident claims case, you can hold that the driver was negligent. But in 304A, it cannot be done. It is too well settled. That doctrine is not applicable. Therefore, Murat, this reference to the judgment of Honorable Justice Krishna here, who in turn relies on the doctrine of receipts or acquitter, in my humble submission is contrary to the settled position of law, and the law has been settled at least in several cases. This is my humble submission. Therefore, what is stated in Narsingh Rao, that because he has got this statement of law, Murat, so far Narsingh Rao is concerned, I got total disagreement. Reason is this. What is the doctrine applied? Receipts or acquitter. When it has been so held that the doctrine is not at all applicable to criminal law, then Murat, this statement of law made in this case is to be rejected. It is my humble submission. Page 141, 140 minutes. Raghuveer Singh, you may kindly come to page 567, paragraph 11. The last submission.
Paragraph 11.
567, page 567.
Your page 147.
Yes. The last submission turns on the presumption under section 4 of the Act, Old Act. It is equivalent to section 20 now. The contention of counsel for the appellant that the presumption available on section 4 of the act cannot be raised in the present case since the charge is under section 5 only, that is equivalent to 13 only now. Read in section 5(2), that is 13(2), is apparently attractive, but we may notice that even if the statutory presumption is unavailable, court may presume what may in the ordinary courts be most probable inference, that an assistant station master, like the accused has in his hand a marked currency note made over to him by a passenger whose bedding has been detained by him, for which no credible explanation is forthcoming, and he is caught red-handed with the note, is a case of reciprocal accuser. The very thing speaks for itself in the circumstances. We need not therefore scrutinize the substance of the argument based on the inapplicability of section 4. When the doctrine of reciprocal accuser is applied to invoke the presumption. But this is contrary, Murad, to the law laid down by this honorable court in several judgments, Murad. Yes. Murad, the recent judgment of this honorable court, Murad, compilation,
Because the bedding was
page
seized by him.
163,
The bedding was
three judgments are again. The judgment of Honorable Justice Krishna Murari. Page 163 and relevant portion, but is in paragraph 9. Page 170, paragraph 9. Here it would be useful to advert to the dictum in the case of Syed Akbar versus State of Karnataka, in which this court proceeded on the basis that doctrine of reciprocal accuser censure would not apply to a criminal case, as its applicability in an action for injury by negligence is well known. In Syed Akbar, that judgment is at page 149 in my compilation, paragraph 29. Such a simplified and pragmatic application of the notion of reciprocal accuser as a part of the general mode of inferring a fact in issue from another circumstantial fact is subject to all the principles, the satisfaction of which is essential before an accused can be convicted on the basis of circumstantial evidence alone. These are firstly all the circumstances, secondly, etc., etc. Then, Murad, in this case, the doctrine of reciprocal accuser, Murad, has been held to be inapplicable. That is a paragraph 11. Bearing in mind of principles which have been laid down in decisions of this court, we are of the view that the court below were not justified in convicting the apparent negligence, not under section 304A, not invoking this doctrine. Not I am relying on two judgments of Syed Akbar and Nanju Dappa, that is by a three-judge bench. Bearing in mind, it has been very clearly held that the doctrine of reciprocal accuser is not at all applicable. Therefore, I therefore, though I broadly accept the view taken in Narsingh Rao, but so far as this proposition that by means of inference, applying the doctrine of reciprocal accuser, there can be a conclusion arrived at that he demanded, attainment is proved, or acceptance is proved, may not be the correct position of law, it is by humble submission. Then, that is regarding Narsingh Rao. The next judgment, Murad, is Subhash versus State of Gujarat. That you will also find as page 29. Now this is Murad, by pre-judgment Murad. What is the difference between acceptance and obtainment? That he dealt with Murad in this case in paragraph 5 onwards Murad. So let me kindly come to paragraph 5. It is very clearly stated. In our view,
29.
paragraph 5 Murad.
Yes.
One second.
In our view, mere acceptance of money without there being any other evidence would not be sufficient for convicting the accused under section 13 only. Mere acceptance. But punch witness will say that during the raid, during the trap, I went along with him. He paid them, he gave the money, he received it. That by itself is not sufficient. But for that section, without there being any other evidence, would not be sufficient for convicting the accused under section 13 only, because obtainment is required. Not 13 is extracted, then para 6 Murad. In section 7 and 13(1)(a) and B of the Act, the legislature has specifically used the word accepts or obtains. As again this, there is departure in the legislative language used in section 1D of section 13, that is 13(1)(d), and it is omitted the word accepts and it has emphasized the word obtains. Further, the ingredient of subclause 1 is that by corrupt or illegal means a public servant obtains any valuable thing or pecuniary advantage under subclause 2. He obtains such thing by abusing his position. 3. Contemplates that while holding office as a public servant, he obtains for any person any valuable thing or pecuniary advantage without any public interest. Therefore, for convicting the person under section 13(1)(d), there must be evidence on record that the accused obtained for himself or for any other person any valuable thing or pecuniary advantage by either corrupt or illegal means or by abusing his official position as a public servant, or he obtained for any person any valuable thing or pecuniary advantage without any public interest. This court, so therefore, Murad, what is to be proved is obtainment. This court interpreted similar provisions under the Prevention of Corruption of 1947, then that is extracted. Paragraph 8, Murad. Similarly, another case is extracted regarding 13(1)(d). Then, Murad, paragraph 9 is important. Paragraph 9. Gave me the position of statutory presumption under section 20 of the Act and is available for the offence under section 7 or 11 or clause A of or clause B of subsection 1 of section 13 and not for clause 13(1)(d). So there is no presumption of section 20. So the next judgment would be Murad at C.K. Damodaran 1997. Page 34, you will have to pay attention. This is very important judgment, Murad, distinguishing between obtainment and acceptance. But it is paragraph 9 onwards, page 39 of the compilation, 39. Paragraph 9. Before we proceed to consider whether the prosecution has in fact succeeded in proving that the appellant demanded bribe from the hospital authorities, it will be necessary to ascertain whether such a demand is an essential ingredient of the offence in question. To sustain the charge under section 161 CRP IPC, since omitted from IPC and incorporated section 7 of the Prevention of Corruption Act of 1988, with certain modifications against the appellant, the prosecution was required to prove that the appellant was a public servant at the material time. The appellant accepted or obtained from PW9 a gratification other than legal remuneration. The gratification was for exempting the hospital in question from its liability to pay statutory provident fund contribution. So far as the other offence is concerned, section 5(1)(d) of the Act, now replaced by section 13(1)(d), lays down that if a public servant by corrupt or illegal means or by other abusing his position as a public servant obtains for himself or for any other person any valuable thing or pecuniary advantage to be guilty of criminal misconduct. And section 5(2) thereof, which corresponds to section 13(2) of the Act, speaks of punishment, etc. Then, Murat, paragraph 11. From a combined reading of section 161 and 41 of the Act, it is evident that if the instant case, the prosecution has succeeded in proving that the appellant was a public servant at the material time and that he had accepted ₹1,000 from PWD. That is to prove not mere receipt, accepted or obtained. Then, Mullard, few lines thereafter. According to the shorter Oxford Dictionary, accept means to take or receive with a consenting mind. Obviously, such a consent can be established not only by leading evidence of prior agreement, but also from the circumstances surrounding the transaction itself without proof of such agreement. If an acquaintance of a public servant in expectation and with the hope that in future, if need be, he would be able to get some official favor from him, voluntarily offers any gratification, and if the public servant willingly takes or receives such gratification, it would certainly amount to acceptance within the meaning of section 161. It cannot be said, therefore, as an abstract proposition of law that without a prior demand, there cannot be acceptance. The position will, however, be different. So far as offense under section 51D, that is section 52 of the Act is concerned. For such an offense, prosecution has to prove the accused obtained the valuable thing or pecuniary advantage by corrupt or illegal means or by otherwise abusing his position as a public servant, and that too without the aid of the statutory presumption of section 4(1) of the Act. So therefore, Mullard, acceptance is different from obtainment. That is highlighted, Mullard, in this judgment, Mullard. Paragraph 13 and 14 also says the same thing. I do not want to take much time of this on the report. Then, Mullard, the last judgment, which I would refer to, Mullard,
Please read the last sentence of para 11.
Yes, Mullard. Yes, Mullard. That's,
It cannot be said.
it cannot be said, therefore, as an abstract proposition, that qualification is not highly considered. As an abstract proposition of law that without a prior demand, there cannot be an acceptance. But demand is relatable to obtainment. But so far acceptance is concerned, but the bribe giver has to offer and the public servant should accept it, receive it simply. Offer and acceptance.
They also say that earlier you used the term consenting mind.
Consenting mind. It falls within the question of fact, opposite to evidence. I can't go forward over there. But my humble
If it is given in your hand, you keep it in your pocket, so it is without consent.
But I say.
It is given in your hand.
Yes,
After taking in hand, you put it in your pocket.
yes,
Then thereafter immediately you are searched.
yes.
So that is without consenting mind, that acceptance.
Consenting mind, what for is the consent? But consenting mind, I agree. But I say, but he owed money to me, he gave that. With consent, I received and kept it in my pocket.
So therefore that presumption will have to be rebutted by you.
True. Not consenting mind means what for is the consent? Not consenting mind.
You will have to prove evidence that no, it is not in relation to some work which was to be done, but it was in relation to some private transaction between me and him.
Murat, at any rate, Murat, the principle beyond reasonable doubt is applicable. Murat, consenting mind means I consented. The very fact that I kept it in my pocket means that I consented. What for is the consent? Not I consented, I received it as a loan amount.
No, like
The consent.
like Satyanarayana Murthy.
Yes.
It was given to me. The complainant says I had given it to him to deposit it in the bank.
Yes. That is a consent. My consenting mind was that I received it as a loan.
So there was the consent was not to accept it as a gratification.
Yes.
Or a reward.
Yes.
So therefore, in facts of each case, if you are found to have accepted the money, at least insofar as section 7 is concerned.
Yes. Explanation is to be offered.
You willingly accept his consent without demur.
Yes.
One of the cases was that it was just put in the pocket.
Yes.
So that will be there was no consenting mind.
Yes.
but
Here-
accepting in your hand.
Yes.
And then keeping it, so isn't there application of mind to give your consent?
Yes, there is consent. There is consent. What for is the consent is the question.
So therefore, in that case, the presumption under section 20 would be applicable and the burden would shift on you to prove that it was not for illegal gratification.
Sir, section 20, but 20 can be raised, provided, but again it is a presumption of section 140, not 20 presumption. 20 presumption comes later, but it is not I receive it, I keep it. Which means what is the presumption? There is a consent on my part. This presumption
Like Justice-
is under section 140.
Like Justice Thomas has given an illustration in Narsingh Rao.
Right.
He has used 114. If a stolen property is found in possession of a particular person, then the presumption is that he has stolen that property and he will have to rebut it.
Yes.
Is received, this stolen.
Received also stolen.
But 114, speaks of the natural human conduct. Going with the natural human conduct, the court is permitted to presume something, may presume. But what is the conduct here? I received the money, I kept it in my pocket. What is the logical presumption? Presumption can be, it's a factual presumption. Yes, knowingly I received it, I kept it. But it does not give rise to a presumption that I received it as a bribe. But
Fact, you remember there are cases in our state where the tainted money, when the punch witnesses came, the inspector arrives, the money is followed.
yes.
Now what is the consenting mind? He gave it as a lunch.
But in that case, if I say, depending upon facts of each case, it is to be decided. Section 114 is not a straitjacket formula that is formulated. But section 114 gives vast discretion to the court to act on the natural human conduct. For a guilty man, for eating the money, exposes his guilty mind. So therefore, presumption is guilty.
No, according to your argument, it does not expose because if the demand is not proved, he can eat it as a breakfast.
No, that is regarding to 20 presumption. Let me not confuse myself between 20 and 114. To raise a presumption of 114, demand is not required. That is for section 20 presumption. Section 114 presumption is based on natural human conduct. I receive the money, on seeing the police eat. What is the natural presumption, logical presumption? I have done something wrong. But if I keep the money in my pocket, what is the presumption? Presumption is that I received it, I kept it. Consenting mind is there. What for is the consent? That is the issue. As per in Satyanarayana Murthy case, there is evidence that money was given as a to deposit in the bank.
And Satyanarayana Murthy was a Mandal revenue officer. Somebody gives money to Mandal revenue officer to deposit it back. Very
They are
excellent.
friends. They are friends, He can give it. I am an illiterate
It
person.
only happened in Satyanarayana Murthy case.
But I am an illiterate person. I go to my friend who is a public servant, give the money, please kindly help me deposit in the bank tomorrow. What is wrong in there?
But then who gave the complaint? Why do you go give the complaint?
Yes. Then Murat,
This position.
you find the other judgments I have
When-
submitted, Murat,
And last two
for the other. Special request, only 1 minute, I have concluded. Not in my written submission, Murat.
Yes.
I have, in page 15,
You cannot say that it is without.
paragraph 41, Murat. With great respect, it is humbly submitted that the issue as framed has more than one defect and therefore the issue needs to be reframed accordingly. That
We can send it back.
So we are. English law means direct evidence here.
Right, we are dealing with the Indian law,
Yes.
therefore issues to be reframed. But in the absence of evidence of complainant, direct or primary evidence of demand, Murat, this is wrong.
No, it's the.
Then Murat, or Sapara 2, the expression primary evidence as to in the issue is inappropriate. inferential detection of culpability of guilt, there can be no inference of guilt at all unless it is provided in the act. Section 29 of the POCSO Act gives such inference, such presumption. Nowhere, this is also to be reframed. So, to put it in nutshell, my humble submission in answer to this, apart from the evidence of the defect of complaint proof, now no more. If there is any other evidence, either circumstantial, direct, or giving rise to a presumption of section 114, there can be conviction. In a given case, it is to be seen whether there is any other evidence or not. This is my humble submission in answer to this.
I think how many of you in the afternoon? How many? You may. Solicitor will.
Also, my case is hostile witness privilege.
Huh?
In my case, also, my lord, complainant turns hostile. That is my case.
Only on this legal question, Only
Yes.
on legal question referred.
But I am for the accused.
Sugamutru has, I think we have substantially covered everything. Only 5 minutes we will give to the others, right? 5 minutes, 5 minutes. To others. No, we will give you 10 minutes. Nothing beyond. Today we have to close. That we will see. When you begin, let us see where you take leaders. No, we are not deciding anything on facts, Mr. Jay. Only on the question of law.
In the absence of the evidence relating demand,
Yes.
can he be convicted merely on the basis of the recovery MO by invoking 20?
That is the question referred, we will answer. See, to put it shortly, when the complainant dies or the complainant, hostile. Nagamuthu has a lot of objection for this, hostile. Anyhow, when the complainant turns hostile, can you look into the other evidence on record? That's the only point.
The answer of that question, if a complainant is absent, complainant not available, or complainant died, all these things and all, can he merely acquit the accused on that reason? No, my submission.
That is the point.
The answer is, you can look into other evidence also, but provided other evidence indicating the demand.
No, that is on appreciation part. That is on appreciation. See, this is the short point. We don't want long arguments. We have understood what the point is. We are not going to decide all these factual aspects. They will go to the bench, respective bench, right? This is the only point. All right, we will come back at 2.
I'll be assisting you lordship for the state of Punjab.
State also can't have different arguments.
No, not.
I had handed over two compilations on Thursday, my lords, your lordships had.
Give us those compilations.
Lord, your lordship may hear you first.
We will hear you, we will hear. We'll hear you.
Your lordship, there are certain aspects which are not. And your lordship are deciding a constitutional.
We will hear you in detail, sir. We'll hear you. So that we'll appreciate more. Once we hear the other side, it will be.
My land friend is already pointed out 114, my lord.
All right, wait, yes.
My lords, if your lordships will look at the first compilation, my lords, in first compilation, we have tried to give my lords first, what was the basis?
Which is the compilation?
My lords, there were two compilations that
yes.
we handed over on Thursday, my lords. Compilation 1 and 2. The first one, my lords, is we have first put in, my lords, the Law Commission reports. Then we have put in the 1947 Act and the 88 Act. I don't want to take now your lordships into the theory of it. My learned senior colleague, Mr. Nagaputtu, has taken your lordships through it, my lords. But now, my lords, for the importance of the PC Act, your lordships will have already seen Narsimha, my lords, Narsinga Rao that your lordships have seen at length. Permit me to show, my lords, take your lordships back to Narsinga Rao to show that it was a reference also. Narsinga Rao was not a ordinary judgment that your lordships were deciding. That was also a reference. If your lordships will take up Narsinga Rao again, it is at page 85 of this compilation, my lords.
We will refer to his compilations.
As your lordships deem
Page 19.
As your lordships deem appropriate.
Familiar with that.
Please, my lords. Your lordships may look at the first para itself, Justice Thomas's judgment, first para. Can a legal presumption be based on factual presumption? The latter is discretionary, whereas the former is compulsory. Such a question arose in this appeal, and in view of the importance of issue, a two-judge bench has referred this case to be heard by a larger bench. The legal presumption envisaged under Section 20 of the PC Act is that on proof of certain fact, the court shall presume certain other fact. When there is no direct evidence for establishing the primary fact, the court has to depend upon the process of inference drawn from other facts to reach the said primary fact. The crux of the question involved, therefore, is whether an inference thus made could be used as a premise for the compulsory presumption envisaged in Section 20 of the Act. So this reference question is very important in my respectful submission, my lords, because this reference question itself deals with when a factual presumption will form the basis for a legal presumption. And this reference has been answered. Your lordships have seen. The submissions were made. Para 8, if your lordships see, the argument was made that your lordships may see para 8, my lords. The argument is made that first, that the presumption under Section 20 could be drawn only when prosecution succeeded in establishing with the direct evidence that delinquent public servant accepted or obtained. My lords, accepted or obtained. Your lordships have seen Section 20 multiple times. Section 20 does not require demand. Section 20, if your lordships will have, again, my lords, it's this judgment in para 12.
What Mr. Nagaputtu says is there is a distinction between acceptance and receipt. And according to him, for acceptance, there has to be a receipt, the demand and receipt both.
My lords, my respectful submission is your lordships may, my lords, as a constitution bench, not go into the invitation that my learned senior colleague has, my lords, very skillfully brought to your lordships' difference between acceptance and obtainment. It is not necessary that obtainment is always without an offer. The distinction that was sought to be made was that acceptance is if somebody is offering something and you are accepting. And obtainment is not without an offer. Somebody is not offering, but you're still trying to obtain. An offer can also subsequently become an obtainment. And these are, my lords, these are, to my respectful submission, my lords, these are distinctions which are not there in the statute. And therefore, what is necessary is acceptance, obtainment to be proved. Not in this manner that there has to be an offer first.
No, that is in the realm of appreciation. See, now the question for referred is very simple, as we told you earlier.
Yes.
Whether other evidences have, if the complainant dies,
yes, my lord,
or he turns hostile,
please, my lord,
what should happen? Should the proceedings come to an end, or other evidence can be looked into? This is the simple question before us.
I bound. My lord, so our,
To our mind, I think Satyanarayan, Satyanarayan, what is that? Satyanarayan
yes,
Rao.
Satyanarayan.
Murthy.
Satyanarayan Murthy. I think that gives a complete answer perhaps.
My lord, Satyanarayan Murthy is an aberration to the law that otherwise your lordships have laid down, and we've also made an index of where all Satyanarayan Murthy has been followed. That is why I want your lordships to look at Narsingha Rao first.
What is wrong with Satyanarayana's views?
My lord, Satyanarayan on preposition of law, it in a manner of speaking says that only when other evidence is not available. But in that case, as my lord's Justice Gavai rightly pointed out, PW1's evidence, who was a public officer along with that person, who says that the papers and the money both was given. He said, have you brought the money? And my lords,
Do you have any objection
yes, ma'am.
if the complainant dies or he turns hostile or he is not available?
Yes, ma'am.
Do you have any objection to consider all the other evidence on record and come to a conclusion?
That is our response.
Now, some of the judgments have said, no, it is end of the road.
Yes, ma'am.
Once he dies or turns hostile.
We have a problem with that end of the road. We want other evidence.
Therefore, Satyanarayan Murthy says, all the other evidence has to be considered and appreciated one way or the other. Do you have any objection for that proposition?
My lords, I bow down. For the preposition, we have no
Then
objection.
what is the difference between you and Nagamuthu's submission? There is
My lords-
absolutely nothing.
My lords, your lordship is
What is the
right.
difference?
Or your lordship is right. On law, we are agreeing. Only my
We will not go into all these niceties, what you are projecting. That is, the division bench on the facts of the case.
I bow down, my lords.
The court has to deal with it. We are not deciding the case on facts.
Yes, my lords.
I know that.
My lords, I bow down if your lordships are on a
We are not deciding all those questions.
Yes, my
All
lords.
these questions may have to be answered while hearing your appeal on merits.
My lords, I bow down, my lords.
Yes.
On facts, we will argue
If
before.
that is so, what is wrong with Satyanarayana Murthy's proposition?
My lords, the manner in which that preposition has been applied to the facts and the manner in which it has been followed.
Only on principle of law.
That's all.
They may have wrongly applied that principle.
But my lords, now that your lordships as a constitution bench are considering this, your lordships will have to look at how Satyanarayan Murthy is being read by successive benches. And my lords, despite other evidences being available,
No,
in the absence
that's why
of,
we are answering that question.
Yes, my
We are
lords.
going to answer that.
and in our respectful submission, my lords, this Narsingha Rao, which was a reference that your
I
lords.
think correctly reframed that question, Nagamuthu's submissions you have seen.
Yes, my
The
lords.
question, has been correctly reframed also.
Yes, my lords.
And that has to be answered, that's all.
My lords, your lordships may
Yes,
also
want to
look
say.
at, please kindly look at our second compilation. We have made 3 categories in the second compilation. Kindly just look at the index, my lords. If your lordships have the index of the second compilation. This is compilation 2 on behalf of the respondents.
Oh, it's here. Yes.
My lords, there are 3 categories in this. First is where the complainant is dead. There are 2 judgments in this, my lords. That is State of AP versus Vasudeva Rao and Satyanarayan that your lordships have already seen. The second category is where the complainant turned hostile. My lords, where the complainant is dead also, Vasudeva Rao convicts and Satyanarayan Murthy acquits. In the second category where complainant has turned hostile, Hazari Lal convicts. Kishan Chand Mangal convicts. Narsingha Rao convicts. And then, my lords, Banarsi Das, Jairaj, these are acquittals. Sukhna, Kishan Chandar. So we have set out these.
That means the other evidence is looked into.
Yes, my lords. So other evidence is looked into, and this is a. My lords, third category is also very interesting. We've put it here in the index only, if your lordships will see. We've tried to cull out from the index itself that what was the demand, what was the official position, and what is held. In the index itself, your lordships will note, and we've given the paras.
Questions as to may presume, shall presume, it is all for the regular court.
I bow down, but my lords,
Only answer this proposition.
yes,
Because there are different views on this question.
and your lordships may also consider, my lords, that not only your lordships' view, even in other judgments, has been that indirect evidence can be considered. This is not confined to PC Act alone, myself. Your Lordships. This is a rule of evidence. This is a rule that applies to other penal offences also. Second aspect is, Your Lordships, my lords, my respectful submission is not go into the aspect of acceptance and obtainment that, my lords, that my learned colleague has, my lords, propounded for Your Lordships' kind consideration. Also, Section 20, the presumption under Section 20. These are the only 2 points that I am differing with my learned colleague, my lords. One is on the aspect of obtainment and acceptance. Secondly, that Section 20 presumption cannot be applied till demand, acceptance, obtainment is proved. Section 20 does not speak about
that is
demand.
again appreciation part. No?
But my lords, if Your Lordships say anything, my lords, on any of these aspects, this will become a binding precedent of law, which
There should be beyond the reference, the question referred to us, all this.
my lords,
Incidentally, we have heard all these things, but
yes, my lords.
that is for better understanding.
But my lords,
For our better understanding,
So,
we have heard all these questions.
my lords, I'm only pointing out the 2 aspects on which we differ from the note that my learned senior colleague has given. Your Lordships may kindly consider those aspects and
We need not go into what would be the nature of evidence. We can only say that in the absence of the complainant, either he dies or he becomes hostile.
yes, my lord.
It can be proved by other evidence. That's all.
And that is a settled proposition is what is our respectful submission.
And
my
whether the evidence is sufficient or not will depend on facts of each case.
It will depend on facts of the case. But my lords, Your Lordships will be mindful of this fact. My lords, kindly appreciate that there is a line of judgments that have followed Satyanarayan. They have simply, my lords, brushed over any other evidence that was there just because the complainant had either died or he was not available or post-time.
No, Satyanarayan, to answer your query, Satyanarayan clearly says no, the other evidence is not available.
But my lords, the manner in which it has been followed is a problem for PC Act, my lords, and these are concurrent convictions that have been interfered, Your Lordships.
Concurrent errors, perhaps.
Perhaps, my lords, perhaps if where there is a concurrent error, my lords, then the state is also not interested in prosecuting it. But Lordships are, that's why we in the first compilation have given the background of how PC Act, Your Lordships have examined the importance of PC Act. It is something that really strikes at the national integrity and the national unity itself. The corruption is making the country hollow. So therefore, these stringent provisions should be given its full interpretation rather than, my lords, reading into something like Section 20. If presumption cannot be drawn without a demand, then it is not what the section says. Section only says if obtainment and acceptance is there, then it has to be proved.
It's not a question referred to us, no?
My lords, but kindly don't make a reference on that is my respectful submission.
All right. Anything else? That's all.
Great.
You want to say, Mr.
But I only want to make a submission.
5 minutes, huh? 5
Not 5 minutes.
Then the rest of the time we will,
Give it-
will conclude.
Give it
You
to
have the
them.
benefit of hearing everybody and you must conclude.
I will conclude, my lord, and in fact, I will not go beyond
My submission before.
the note.
We
I
will hear you, Jain Sahib will, 5 minutes we will give.
Yes, my lord.
Yes, yes.
Well, in fact, my lord, your lordship, I'm passing on a note on this aspect itself.
Where is
But
the
is coming close, my lord. Your lordship will see, my lord, your lordships are referring to Satyanarayan Murthy. Satyanarayan Murthy is under reference where they held in the absence of demand, don't look at anything else. Kindly have, my lord, Satyanarayan Murthy for a minute. I think what your lordships were referring to was, my lord, in fact, Rao's case. Kindly have, my lord, Satyanarayan Murthy.
Yes.
Your lordship has.
No, we have your note. What do you want?
No, my lord, I want to show your lordship Satyanarayan Murthy that your lordship has
You want us
said.
to see the judgment?
Yes, my lord. The judgment is under reference as my lord saying that it did not take into consideration the judgment in the Rao's case. Kindly have that, my lord. The head note itself, my lord, Satyanarayan Murthy.
Just 1 second. Huh?
At page, my lord, it's at page number 10.
Yes, page 10.
The head note itself, my lord. Now it says illegal gratification trap case, proof of demand necessity of for conviction, demand not proved as complainant had died before the trial, evidence of other witnesses not sufficient to prove demand. So, my lord, this is what was held in Satyanarayan Murthy.
Yes.
So, my lord, because of this, because of dichotomy between this judgment and, my lord, the judgment prior to this which is, my lord, Narsinga Rao.
Yes.
If your lordship will have, my lord, page number 19 now.
Yes, 19.
So, page 19 is what was existing, my lord, when these two judgments were passed.
Yes, we have.
page 19.
Yes.
So, my lord, the view of this honorable court while answering that reference was, my lord, that if there is no demand, you can look at other evidences that are on record. And that our other evidences on record are to the effect, my lord, pre-raid proceedings, post-raid proceedings, recovery of money. So, my lord, that fact has to be, my lord, taken into consideration. Now, your lordship will have for a minute, my lord, 2 notes I have passed on to your lordship. One is a very smaller note, which, my lord, starts in the first page. One is a little bulkier, my lord, they should have named it as 1 and 2, but it starts with page 1. 1. Is what my learned colleague said, that it's a menace and this menace has to be curbed, and this menace, my lord, in view of an effort, collective effort of the investigating agency also to muster evidence of this nature, which is only within the knowledge or the mind of the accused at that point of time. My lord, to say that there is no demand, thus acquit will be, my lord, preposterous, bring about preposterous results, and that's the reference before your lordship. Kindly have the first judgment, my lord. Lord, it's reproduced. I have not burdened your lordships with, Lord, the bulky judgments. If your lordship says, I'll file it also. Lord, the first judgment is State of UP versus D.K. Ghosh. My Lord Justice Gavai has it, my Lord. It's
We have page 2.
Yes, my Lord, page 2.
We have.
So, my Lord, this is a 3-judge bench. My Lord, they say, by and large, citizen is somewhat reluctant. They say, my Lord, what is the manner, tenor of, my Lord, lodging such complaints? By and large, the citizen is somewhat reluctant rather than anxious to complain to the Vigilance Department and have a trap arranged even if an illegal gratification is demanded by a government servant. There are numerous reasons for reluctance. In the first place, he has to make a number of visits to the office of the Vigilance Department and to wait on a number of officers. He has to provide his own currency notes for arranging a trap. He has to come.
These are all in the realm of appreciation.
The realm is
The simple.
no, why I say so?
Going to all, we are not going to answer all these questions.
I am not asking, my lord. What I'm trying to, my lord, point out to the court is that simpliciter absence of demand, my lord, cannot efface, my lord, efface evidence of this nature which has come. I'm sorry for being repetitive, but my lord, this is also crucial evidence which is in the form of a circumstantial
You
evidence.
argue that case when the matter is taken
Yes, my
for
lord.
hearing.
Yes, yes.
Supposing if we hear tomorrow, if supposing we opine, let us assume that complaint, the death of a complainant or his turning hostile will not come to an end to the proceedings.
Yes, my lord.
Thereafter, you argue everything.
So
on
that's
merits.
what these two
We are
judgments.
not going to answer all these questions.
Very well. Now, that's what these two judgments held. That in the absence of demand, stop. Let the person go free. But, my lord, in Rao's case, your lordships have held, my lord, that look at the other evidence, and that is the dichotomy which your lordships are examining today. My lord, which out of these two sets of judgments will be applicable and is good law? Kindly have, my lords, for a minute. My lord, let's go further. My lord, I couldn't make it more concise and precise than what it is,
All right.
because it all leads to answering that reference to your lordship. My lord, the next case is T. Shankar Prasad versus State.
Yes, Shankar Prasad.
Yes.
Again, Andhra Pradesh.
Lord, proof of fact depends upon the degree. So, my lord,
One second.
Shankar Prasad.
T. Shankar, proof of fact depends upon the degree of probability of its having existed. The standard required for reaching such a supposition is that a prudent man acting in an important matter concerning him. Fletcher, Moulton, and so, my lord, next page. Proof does not mean proof to rigid mathematical demonstration, because what was argued from the other side was, my lord, who will prove? Is this primary? What is proof? So this answers that point, my lord. Proof of rigid mathematical demonstration, because that is impossible. It must mean such evidence as would induce a reasonable man to come to a particular conclusion. The said observation has stood the test of time and can now be followed as the standard of proof. In reaching the conclusion, the court can use the process of inferences to be drawn from facts produced or proved. Such inferences are akin to presumptions in law. Law gives absolute discretion to the court to presume the existence of any fact which it thinks likely to have happened. In that process, the court may have regard to
case, they said that proof of demand is essential to prove an offense under section 7 and 13.
yes, bro.
Now, if the complainant has died, then the question of proof of demand, it need not be from the complainant's evidence because he is
Himself.
dead.
Yes,
It can be looked at from other evidence.
yes, Lord.
But what you are arguing now is that proof of demand need not be proved at all. That is not what Satyanarayan Murthy says.
Not,
Proof of demand is essential,
not demand.
but complainant is not there to give that fact, to prove that fact. Then you require other evidence alieni. Other evidence and circumstances you look, you can infer there is a proof of demand. You may presume either it is a discretion, then shall presume under section 20 it is no discretion, it is mandatory.
Absolutely.
But you are now arguing it is not necessary to prove demand. If there is evidence, then demand has to be inferred. That is not what Satyanarayan said.
What I'm saying is that in the absence of complainant, it might be very difficult to actually prove the demand. It might, because he is the person who has been demanded from. He is the individual who has faced the demand. Today, the situation is that how do I prove other factors? As has been held in Murthy, that if there is no demand, please let him go, which is not the correct position. So, that proof, the demand can be proved by other factors. There is an FIR, there is an inquest,
But
There
if there are no other material to prove the demand,
if there is no other material, then it will be for the court to decide looking into.
then it has to be an acquittal.
Can be
Because
if there is no.
demand is essential to bring him to book.
But in the case of there is no demand and no evidence, obviously has to be an acquittal. So let's take a case of
The submission was it is not necessary to prove a demand.
I'm sorry if it came across like that. I'm sorry, but in the case of 302, there is a complainant and the complainant dies. So there is no actual eyewitness of the incident. Because there is no eyewitness there, does not mean that the accused is going to be acquitted. Your lordship will look at the other aspects of the matter.
This is what we are also suggesting.
Exactly.
This is also we are
Exactly,
That's what Nagamuthu also said.
Yes.
Mr.
He has
Nagamurthu
not
said on
you
first
acquit
day.
him. He has not said complainant is dead or turns hostile. Acquit him. He has not said that.
On the-
Look into all other material
Absolutely.
and circumstances.
So there,
Proceed.
so there cannot be a mathematical situation where no demand, so acquittal.
All right. Come.
We have the next.
Other point.
Yes,
You have
Lord.
understood.
Yes, yes.
It's only a repetition.
No, I'm sorry, these are judgments which are not cited,
That
so I
will
thought.
see, that will
So I thought I'll point out to the
All right,
court.
sir. All right.
Your lordship may kindly turn over, my lord. Page 5 straight away.
Yes, we have.
Page 5 of this note itself.
Yes.
Your lordship may read it, well, this is a proposition which I have prepared. Which
This
is,
is not a question referred if I am right.
Lord, in fact,
We at page 5, no?
yes, my lord.
We are not supposed to answer this
No.
actually.
Because in fact, it's a sub-question within the reference, if your lordship will see.
All right, this we will look at.
That's it.
All right.
That your lordship will see.
All right, sir. All right.
But there's one more note which I have placed on record.
Yes, we have.
Which takes into consideration all the judgments, including the ones that were cited by Mr. Nagamurthu. I mean, anything in, I'll make a submission.
All right, all right. Yes, now, who else here?
Last aspect, my lord, before I say it is, my lord, Justice Krishna here judgment says that even if section 20 presumption is not available, which was, my lord, under the old act section 4, my lord, the court is free to my lords, go and invoke 114 also in the facts of this case. That judgment is also there, my lord, Raghubir Prasad.
Question whether in the absence of evidence of the complainant, direct or primary evidence of demand of illegal gratuity, is it not permissible to draw an inferential deduction of culpability, so and so and so?
Exactly.
To put it simply, if the complainant is not available for some reason, can we not look into, can the other evidence on record and come to some conclusion?
That is what our
That is
submission. That is what
you have
our
followed,
submission.
sir, you have followed.
Absolutely.
Leave it. All right.
Your lordship, my lord, whenever the lordship sees, my lord, those judgments I have signed,
All right.
those extracts I have
We
put.
will see, we will see.
Very well.
Yes, anybody wants short submission, short, 2 minutes. Yes, Prasad will have 1 minute
Yes, my lord.
for your.
My lords, if a complainant dies, it does not mean that his complaint has died or his information has died.
All right, if the complainant dies, it doesn't mean that complaint dies.
Yes. Or his information the information which he has given.
that-
Now, my lords, now he can prove, the prosecution can prove it's not fatal for the reason that the document is already there. The document can be proved. The contents of the document can be proved under section 61 minutes. A document is the primary evidence minutes under section 62 minutes. Now, minutes for the purposes that since he has died, a person who would have taken out thereafter, because normally in a criminal matter, someone who takes on the theory, he is also examined. The documents, whether the document is there or not, the moment it is done, that someone has done it, or I have typed it on the instruction of the complainant who's not anymore, because that can be proved. The contents of that document can also be proved by virtue of section 61 and 62 minutes.
You are right.
And minutes also in case we have to check his handwriting.
See,
Or
Nagamuthu said, in 4 ways you can prove the case.
minutes.
4 ways he gave us.
Yes, minutes.
The example, the last one is 114.
Minutes.
of the
That's the
evidence.
presumption. Minutes, even 40
Third is 106.
minutes.
And first and second, I don't remember.
Minutes.
Anyhow, I have made a note.
Minutes, the question in reference clause 1 and clause 3, the instances.
59, section 59.
59.
Then section 63.
Because the document, in case I have given a complaint, I have written a complaint, I have given it to, and thereafter I abscond, I am not at all available. Instance 1 or 3 minutes. My handwriting can be checked. Because your lordships have, the court has power under section 45 and 47 minutes
Yes.
for taking the opinion, and on the basis of that, along with other minutes, relevant circumstantial documents and it can be,
All right.
it's not fatal. Minutes.
All right.
1.5 minutes
Thank
I
you.
complete.
Yes, sir. Basant,
Keep your-
where is Basant?
Yes.
This side. Take 2 minutes. Take 2 minutes.
Lord,
You have to give enough time to Jain sir.
Yes. My lord, for the state, my
I
lord.
prepared a very short.
Let's
All
submit.
right, we'll hear it.
I prepared a very short written submission, my lord. Yes, sir. Yes.
Yes, sir.
Yes, my lord. Lord, at the outset, my lord, according to me, my lord, subject to what your lordships feel, the so-called conflict, my lord, it's a perceived conflict. There is no conflict whatsoever, because there is not a single judgment of this honorable court which says that in a Prevention of Corruption Act under 7 or 13(1)(d), if the complainant either dies or is hostile or is not available, the accused has to be acquitted. There is no judgment. So in Neeraj Datta, the 2-judge bench initially, Justice Bhanumati's reference seems to be, if I may say, utmost respect, on a perception that Satyanarayana Murthy said, if the complainant is dead, that's the end of story. It doesn't say that. What happens to Satyanarayana Murthy is, the complainant is dead. Like Justice Gawai pointed out, PW1, who was another eyewitness, who went along with the complainant when there. Now, if you read that judgment without reading the evidence, even I don't know how that person was lucky, how he got acquitted. But he got acquitted based on acquisition of evidence. But it is not on the basis that because complainant is dead, therefore is equal to acquittal. No judgment. My learned friend, the learned ASG, has produced a set of judgments. Each judgment examines, even in a case where the complainant is dead or hostile or not available, looks at the other evidence. Now, my lord, this situation normally happens in trap cases. In a trap case, while arranging a trap, many times along with the complainant, the police officer says, you stand outside, you please hear what's happening. And when the complainant is dead, the public servant comes and says that I heard him asking for money. So in some cases where the complainant has turned hostile, this honorable court has examined the evidence of the other witness and convicted. So I frankly, my lord, I've tried reading it as to what is and even this judgment, the 3-judge bench says that Satyanarayana Murthy and the other judge, Jairaj, is in conflict with Narsinga Rao. With utmost respect, my lord, maybe my inexperience, but I'm not able to find any conflict. Narsinga Rao says that para 19 of Narsinga Rao, my lord. Lord, you may kindly see para 7 of my note, my lord. Para 7 of I mentioned that, my lord.
Yes.
In Lord, you may kindly see page 4, para 7 of my written submission. 4, para 7 of the written submission, that in Narsinga Rao, page 4, para 7. In Narsinga Rao, the complainant turned hostile. This honorable court, after examining the other evidence adduced by the prosecution, came to the conclusion that even in the absence of direct evidence, the rest of the evidences and circumstances were sufficient to establish the guilt of the accused. Para 19 of the said judgment, I've quoted para 19, Lordship may come to the bold portion at para 5, my lord.
Page 5.
Yes, my lord. Now, before that, my lord, just before. Now, after mentioning section 114, this honorable court says that by itself may not or need not necessarily lead to a presumption that he accepted that amount from somebody else, because there is a possibility of somebody else either stuffing those currency note into his pocket or stealthily inserting the same therein. But the other circumstances which have been proved in this case and those preceding and succeeding the searching out of the tainted currency note are relevant and useful to help the court to draw a factual presumption that the appellant had willingly received the currency notes. So here also is a case where complainant turned hostile. And this honorable court said, correctly held, that even if the hostile, look at the other circumstances and then come to a conclusion. That is in the realm of appreciation. So I can understand if any one judgment had said complainant debt is equal to acquittal, then there is a conflict. No judgment has said that. That is why I've mentioned, my lord, I'm not reading it, my lord. Lord, you may kindly note para 4 and para 5. I mentioned Satyanarayana Murthy and Jairaj, and I've said that in those cases, it is based on appreciation. Right or wrong is a different issue, my lord, but based on appreciation. Like I said, in Satyanarayana Murthy, PW1 eyewitness who was inside and who said, I've seen, but this court did not believe it. Why? I don't know, but did not believe it. Yeah. Now that is on appreciation, not on any question, not on any principle of law. Now, my lord, just one more point, my lord. Lordship may kindly take section 20. I won't take anything. I mentioned that, my lord. Lordship may kindly come. What I'm going to say now, I mentioned at para 9, my lord. Under section 20, my lord, or under any presumption, there is no presumption in law which says you can presume demand. Demand is never presumed, and under section 20, there is no presumption of guilt also. Under section 20, if you prove fact A, fact B, fact C, then there is a presumption of another set of facts. That is section 20. Lordship may kindly see section 20 in this context, my lord. Section 20. The old Act 88 without.
Yes, we have.
Yes, my lord. May I just read that, my lord? Where in any trial of an offence punishable under section 7 or section 11 or clause A or B of section 13(1), it is proved that an accused person, so what they have to prove is the accused person has accepted or obtained or has agreed to accept or attempted to obtain for himself or for any other person any gratification other than legal remuneration. So the burden on the prosecution is to prove that the public servant accepted, obtained, etc. something which is not a legal gratification. If that is proved, then the assumption kicks in. And what is the assumption, my lord? That it is proved that unless the contrary is proved, that he accepted or obtained or agreed to accept or attempted to obtain that gratification or the valuable thing, as the case may be, as a motive or reward, such as mentioned in section 7, or as the case may be, without consideration or for a consideration which knows to be inadequate. So what this says, my lord, is suppose in a trap case. Now I'm caught with money. Now there, the prosecution does not have to prove that he took the money to come and issue this issue this license. He asked me for money. If they prove, then that is it. The presumption kicks in if they prove that I demanded and I accept it. The story ends there. Otherwise, my lord, there's a further proof required. If this presumption was not there, then the prosecution had to prove that this bribe was taken. I took this bribe to issue this license, and then proof has to be led for that. That is not there. Section 20.
See, that you argue when the case is taken up on merits, no?
Yes,
This point you have to argue when your case is taken up merits, when you are reading the evidence, all these things. This is beyond our reference.
I understand. Only the last sentence, my lord. All I'm saying is this section 20, yes, this section 20 presumption can never be used to say that this is the presumption of demand. There is no presumption of demand under the presumption clause.
Anyway, that is not question.
That is not
referred to us.
So the question.
All right.
Question before your lordship, summing up last sentence, the question before your lordship, my lord, according to me, this reference itself was not required because there is no conflict whatsoever.
All right. We have followed. Yes.
Obliged.
Please. Minutes, only two.
Please, my lords. I appear in 501.5, 8 and 12, my lord.
All right.
Just made a very short notes.
All right. Give it fast.
My lords, I'll confine myself only to the reference in the demand, my lord, the interpretation of demand.
See, that is not a question.
No, my lord.
To answer that question.
Please, my lords, on the demand, my lord, my lord, demand as inconsistent with the prime evidence.
In a criminal case, if the accused dies, the proceedings abate. Similarly, if the complaint dies, whether proceedings abate or not is a question. That's all. Or it turns hostile little, if you stretch a bit, little,
yes,
you know.
My lord, we
don't understand this at all.
Yes, my lord. My lord,
these arguments.
My lord, two segregations, my lord. One is absence and death, and one is on hostile basis, my lord. The first, when it comes to the death, my lord, what we are looking for is if there is a demand which incriminates. What the prosecution cannot prove in the death of the complainant is the first demand. But however, there have been no acquittals based only on the ground that the first demand was not proved, my lord. So what remains before the court is whether the second demand is incriminating. The subsequent demand that is made at the time of receipt, if the prosecution can prove that, my lord, that itself would be suffice to answer the demand. In other words, my lord, there has been no case where conviction has been that is made to the complainant that only on an amount of so much your particular work will be done is something made before the filing of the FIR, my lord, to the complainant. Now, subsequent to the death of the complainant, the prosecution will have a lacuna of not being able to prove this crime as the language of the court is in direct evidence, for example. Now, when the trap is set, my lord, when the trap is set, there is a demand which is proved by the shadow witnesses.
Why are you arguing all these things? You argue before the division bench, you know, when we refer the question, you know, when we answer the question, all these things you have to argue.
Yes,
there.
my lord, my submission, my lord, is that demand can be proved. Yes, my lord. Yes, my lord, what I'm enduring.
Vasan said it was unnecessary to refer because there is no, you know, there is no conflict between Satyanarayan and what is the other?
Yes, my lord.
Narsingh Rao.
Yes, yes, my lord. My submission, my lord, is that, my lord, I am submitting the demand can be proved in the absence of the complainant, my lord, pertaining to the reference.
That is sufficient.
Because of the subsequent demand, which can also incriminate him, my lord. Because it was the case of the accused that until the direct evidence of the first demand is not proved, they may have a case. But that is not the submission of us, my lord. And the second ligament, my lord, is that the complainant turning hostile, my lord, again stands on a different footing because some evidence is available with the state. How they corroborate it with the evidence of the other evidence that is available or available on record or not is left to the facts and circumstances of each case.
We understood.
Obliged,
Yes. Now we will go to Mr. Jain Sir. Patil, you want to say something? Only confine yourself to the question referred.
Absolutely, Lords. Can I request my lords to add the question? Can I request my lords to add the question? Lords, it's most appropriately framed. Lords.
All right. We have the question here. Page 3, we have
the question whether absence of evidence of the complainant, direct or primary, of demand. My lords, I'll just pause here. Absence of evidence of demand. My lords, that is by way of direct evidence, my lords, or primary evidence. If there is an absence of evidence of demand, is it permissible to have inferential deduction of culpability?
Yes.
Guilt of the public servant. Lords, if the demand evidence is not there, there is nothing, my lords, in this question which says the complainant is not there, not available, or, my lords, the shadow witness is not available, nothing of that kind. All that is said is, if there is no evidence of demand, can an inferential deduction of culpability or guilt be drawn? The answer to this, my lords, because demand is sine qua non for, my lords, proof of this offence, in the absence of evidence of demand, then, my lords, the question of inferential deduction of guilt would not arise. He has to be, my lords, acquitted. The supplementary question, my lords, which is being raised is because of the last portion of this question. Under section 13(1)(d) read with section 13(2), Prevention of Corruption Act, based on other evidences adduced by the prosecution. My lords, any amount of other evidence in relation to other aspects of the matter, a conviction. Evidence, my lords, which my lords are considering is, if that evidence can definitely be considered. But, my lords, inference of demand cannot be drawn. Inference of guilt in the absence of proof of demand, my lords, it cannot be there. That's what, my lords have, my lords, said. There are two aspects to it again. Section 20, my lords, draws a legal presumption. The legal presumption is confined to a certain aspect. My lords, if a factual presumption is to be raised as to demand, then, my lords, a legal presumption is going to be drawn on a factual presumption. Two presumptions to prove the guilt, my lords, is impermissible. My lords, if my lords sees the decisions which have been referred, my lords, in Jayaraj Satyanarayana, in one decision, my lords, the court specifically says there is no evidence of demand. Therefore, he cannot be convicted. Satyanarayana. My lords, insofar as Narsingh Rao is concerned, the court, my lords, observes in one or two paragraphs, my lords, importantly, as to, my lords, it doesn't mean that no evidence can be there as regards proof of demand. If evidence is to be there, it can be oral evidence, it can be documentary evidence, it can be, my lords, legal presumption, or, my lords, it can be by way of circumstantial evidence. Circumstantial evidence is not inferential evidence. Evidence Act nowhere contemplates inference. I can put 1, 2, 3, 4 circumstances. If the chain is complete, then, my lords, an inference, circumstantial evidence can be taken into account.
May presume inferential only.
My lords, there, my lords,
May presume.
my lords, insofar as these aspects are concerned, it's impermissible. My lords,
All right. We have understood, Patil. All right.
you cannot, my lords. So therefore, my lords, my request is kindly have a look at these decisions which have been referred and the question which is posed. Now, my lords, my learned friend on the other side said, please do not draw the distinction between acceptance and, my lords, obtainment. My lords, there is a definite difference between, my lords, even receipt and acceptance. There's a distance between acceptance, receipt and acceptance. Because, my lords, acceptance, there has to be consenting mind that I have offered you something and I'm accepting that for that offer. Just receiving money, my lords, that's why my lords have said, just being in possession of the money is not proof of, my lords, guilt. It has to travel from, my lords, receipt to acceptance. Insofar as 13 is concerned, what was specifically referred, there is no legal presumption at all under section 20. If there is no legal presumption, then you can only prove these ingredients. One is you prove there is a demand, then you prove there is a receipt. Only when you prove these two things, then only, my lords, there can be conviction. Therefore, my lords, my respectful submission is inferential deduction of guilt is impermissible in law.
Sir, you want to say something? Yes. Take 2 minutes, sir. Take 2 minutes. 3 minutes to take. All right. You start.
I have just.
Give us a written submission. We'll look into that.
I give a short. My.
Demand is a sign of before there can be any.
through the written notes, my lord.
Yes,
My answer would be for the question, short answer.
yes.
In the absence of the evidence of the complainant, because of the non-availability or died hostile and all, whether we can look into the other evidence, that's the
Yes.
question.
Yes.
My answer would be, merely because complainant died hostile and all, it did not automatically resort to acquittal. It can be considered, other documents also can be considered.
Yes.
As Justice Nagaratna puts it correctly, other documents must prove both the demand and receipt.
Yes.
Some indication of demand. If the demand is there in the other evidence, without rehorse the complainant, then that can be considered, whether the evidence is flinchy, whether the evidence reliable, all these things. That can be considered. My submission, that can be considered for acquitting or for acquittal, for conviction. But that's, I have given a short, I have collected all the judgments, I have mentioned that. I have mentioned all the, that is, whether 20 presumption would invoke when demand and, demand as well as receipt, is the two wheels of the chariot. Demand and receipt of the, is the two wings of the bird. The demand and receipt is the two coins of the coin, two sides of the coin. Without demand, we cannot convict on the basis of the recovery only. That's my concern. Will also kindly see the written notes, my lord.
Yes, sir. Yes, sir. We will consider.
I will read it, my lord.
No, we will read, sir. We will.
My lord, if your lordship takes page 3,
we will look
my lord, allow me to.
all right, tell
2
us.
minutes not to go over, my lord.
All right, tell us, sir. Tell us.
My lord, because your lordship say, one, that is 1990 Supreme Court cases, my lord, the para 4 deals with the, suppose in the absence of demand, no question of conviction. Then Mukhtar Singh, my lord, 2017, this is a specific averment, my lord, the 20 presumption cannot be invoked unless there is a demand evidence. Demand evidence can be through complainant or demand evidence through the other evidences or other documents. Lord Melanchthon said the complaint can be considered. In the absence of the complainant, in the death of the complainant, it cannot be looked into. It's a corroborative evidence. The complaint cannot be looked into. Other evidence, punch witness, other witnesses, that can be there.
Yes.
Trap witness goes, demand and all, that can be considered. But it is not a complainant's document, cannot be considered in the absence of the complainant who speaks about the complaint.
Yeah, his author is not there.
Author is not there.
Author is not there.
It's a corroborative, basic law, my lord, criminal law, basic law, it cannot be looked into complainant law. And in fact, my lord, number 2, Mukhtar Singh, this is a case where the paragraph 14, I'm not able to read that paragraph 14 now. The entire thing has been discussed. Mukhtar Singh, very important case. This is a case, deceased died, deceased accused died. Then wife comes to box, a substitute.
No, complainant dies perhaps.
No. Accused. Accused dies, his wife, because the image is there, some image is that remove the image.
Stigma.
Remove the stigma, they can be substituted. In this case, she has been substituted, wife has been substituted, and argued the matter. Demand is not proved to acquitted. Supreme Court acquitted the matter. Then third case, my lord, is Purushothaman, third Purushothaman. In this case also, purely one is treated hostile, but conviction sentence was set aside because there is no requirement of proof in the other evidence.
Because he is a Purushottama.
Poor my lord, Shantama, this is not necessary, purely one is not believed evidence are reliable. That's not important. Then 5, in this case, the decision of Suraj Mal, Delhi administration has been considered. Not the only thing. In Neeraj Kumar, in Narasimha Rao case, 2 judgments referred. Suraj Mal case, as well as the Sitaram case. But referred only, not considered by the Neeraj Kumar, by the Narasimha Rao judgment. It's conflicting judgment, not considered. That was unanswered in respect to those decisions. Then, my lord, number 6, my lord, that is Damodaran Nair. The prosecution has to prove accused demanded obtained the valuability by abusing position. Obtain means to secure or gain as a result of request effort in the form of demand. This is the 2 judges bench, my lord. Is a 1997, even before 2001 judgment. Then next to judgment 7, Sharma, State of Andhra Pradesh, 2 judges bench. Demand and voluntary acceptance of illegal gratification is agreement. Mere recovery of currency note is not sufficient to constitute offence. Then 8, this is also important. State of Maharashtra, Dhyaneshwar, 2 judges bench. Demand is essential, sine qua non for establishing the offence. Demand either through complaint
or other two evidence. Then, my lord, Subair versus State of Kerala, 2009. If the demand acceptance or the illegal gratification of the vital ingredient to procure conviction. Then 10, mere recovery is not enough to entitle the drawing presumption. Then, my lord, 11, 1979, volume 4, SCC 725, 2 judges, Surat Mal. But this Surat Mal judgment has been considered by Narasimha Rao judgment, but not finding even. Then, my lord, 12 is Satyanarayana Murthy. Satyanarayana Murthy, Mr. Nagamuthu referred to some paragraph. Para 22 and 27 is important. Para 22 and 27. Giving a clear verdict, my lord. Then 13, Jayaraj, State of Andhra Pradesh, only when demand is established, the presumption under section 20 will arise. The clear verdict with regard to the presumption 20 will arise, only demand is proved. Demand cannot be presumed. Guilt can be presumed on the basis of materials. Demand cannot be presumed. Then 2015, 10 SEC 230, Selvaraj, these three judges, 215, headline, recovery of money is not enough in the absence of evidence related to demand. Then 15, 2 judges bench, conviction is not sustainable in the absence of proof of demand. Sukanna, this also the 2 judges bench, Sankanna, para 5 and 6, Sukanna case. They refer to the complete presumption when arises. Whether demand, complainant may not be available, complainant may die, but there is some indication of the demand, not a presume. Demand cannot be presumed. Some indication in the other evidence to show that. So my submission, Lord, it can be looked into on the basis of the question whether demand is established. If a demand is established in other evidence, then clear case of acquittals. Thank you, sir.
Thank you.
But in my case, my lords, I've been convicted. The petitioner has been convicted, my lords. Though he is not a public servant.
Please answer only the.
That's what I just wanted to.
That you on merits you argue before the.
No, I just wanted to suggest one this thing, my lords. The question of reference is pertaining to a public servant. But in my case, I'm not a public servant, but still I've been convicted.
That you argue before the.
If your lordship would be kind enough to consider that aspect also. In the absence of demand,
we will only go by answer the question referred. That's all.
Exactly, my lord. But here it says only about public servant. What about if he is not a
As to detag and hear separately.
No, my lords. No, my lords. I'm just suggesting, my lords.
No, sir. No, sir.
The reference is only pertaining to public servant.
No, sir.
So in case, if he is not a public servant also, it can be.
That is not good to us.
You go before the, Yes.
When a complaint turns hostile, he has been prosecuted under section 193, 194 IPC. His conviction ends with an acquittal. Under such circumstances, what is the weightage of the evidence of the hostile witness?
That you have to go and argue before the court, no? which examines your case on merit. No?
The second aspect is, demand is made in the.
Sir, all these questions you have to go there.
I'm not arguing my case, Millard, just.
All right. Next case, all right. Anybody? Yes, Jain sir.
He is raising more questions.
Lord, I am taking your time.
Please enlighten us. But confine yourself to the question referred. Yes.
Your Lordship, I have prepared the note only because of that.
Yes, yes, tell us.
I don't want Your Lordship time to.
Yes.
Your Lordship are deciding an important question. Where, on the one hand, the corruption is there, but at the other hand, there is innocent persons. Lordship can't presume all public servants are corrupt. Same way, we have to consider the corrupt should not go unpunished. That's the question. That's the question ultimately, and that is going on Your Lordship mind. I'm just giving an example, my Lord. Lord, I'm holding a position as a public servant and deciding, taking policy decisions, deciding matters, and my Lord, unknown persons, my Lord, it's not that even known persons, they develop a guts, but they feel that if I'll be there for taking decision in a matter, I'm going to decide contrary to his interest. What is the solution? He feels I can be shunted out by involving me in a corruption matter. It happens below. Number of matters. He goes to my office, plants some money in my drawer or at my house. My house outside room is open. Somebody, I might be inside or might not be there. When I come back in my room is all alone. I am in this room all alone. I picked up the note. I find who has brought this notes, and I'm caught. There is no demand. There is actually no motive. But I am completely defenseless. Just like Milord, a district judge. We know, Milord, certain views also. Some of the district judges or even judges, Milord, we know what is going to happen in the matter. Milord should say normal experience which may tell a lot of things. And I know a particular district judge is the most convicting one. And he is going to convict me. I put something in the drawer. And he comes in his room, chamber, all alone. Nobody is there in the rooms. And he picked up. By the way, the norepinephrine test is positive. What will we do? We are putting an honest officer in a very, very serious condition. I'm putting it, my Lord. These are very crucial aspects, my Lord. Because ultimately, what your Lordship does, once recovery is made, 20, 114, and you are, because I have no defense left, because I am all alone. Your Lordship will not believe me.
You're not referring to mission of sovereignty.
Besides the point. One is told by the accompanying person, Sanjay witness. Somebody goes, this question is not a main report to us. So, Jain, that question is not under reference.
What? Because you are. Why? I am only worried about one thing.
As to whether in the facts and
I am prepared to leave the case here. On only one thing I am worried on, because your Lordship may not permit
whether
exemption to be drawn because of 100.
Not again referred to.
It's not referred. but your lordship may not decide that.
We'll not be, my.
Lord, I am worried about
my
that.
My learned senior brother has.
Because my learned friend has argued.
Mr. Jain, my learned senior brother has been repeatedly saying that we'll not
My lord, right, my lord.
anything more than what is.
My anxiety is, my lord. My learned friend has argued. That was the thing I said. I will argue on the different line. That's the reason, my lord, in the beginning itself, I said I don't agree with my learned friend. Because once 114 is there, my lord, 114 is a general conduct of a person, but not a taking a bribe. On the inference.
See, after evidence is recorded, whether adverse inference to be drawn or not.
But
Listen to us, whether section 20 has to be applied or not. All these questions are in the realm of appreciation. See, we are not going to touch all these aspects. What is the simple question referred to us? When the complainant dies or is not available to give evidence or he turns hostile, whether the complaint abates is a question. Focus on that, and enlighten us on this aspect. That's all. We are not going to touch the facts. We are not going to say all this because it is beyond our jurisdiction. Tomorrow you will say before the 7th judge bench, the court had no jurisdiction to answer this. We don't want to be victims.
Your lordship is not without jurisdiction, because lordship all the jurisdiction.
Please focus on the point.
I'm sorry, my lord, if I'm
not necessary. You come to the point. Directly you come to the point.
I'm coming up. That's the reason I'm saying your lordship, you are deciding 114.
All right, come.
Then I have a problem.
Don't touch
Then
100.
your lordship,
Come to the point.
yes, my lord. If your lordship may see the reference order
Yes.
by division bench,
Yes.
which I mentioned in the very first page of my note,
Yes.
you will find it was in reference to section 20, not 114, my lord. So therefore, this question is framed in reference to section 20 and not 114, my lord. Then, your lordship, my one submission is, my lord, once a presumption, the section 7, 13, 11, these are the three sections. So far as 13 is concerned, 13(1)(d) is concerned, 13(1)(d) will not arise in the case of trap matters. Your lordship may see no acceptance, no attempt to accept. So, and the question of gratification is 13(1)(d), there is no gratification. So 13(d) will not arise in the case of not trap matters. Now the 20, my lord, it has in three parts. Your lordship may just come to, I'm not taking entire lot, only relevant. My learned friend has already argued difference between demand and acceptance, my lord. I need not, my lord, bother your lordship, but I have mentioned it. Then your lordship may just come to section 20, my lord. Page 5. Page 5.
Yes.
Yes, Lord. Page 5, bottom it starts, Lord. And section I have quoted on the next page. And that underlined portion has an importance. Wherein a trial of an offence on issue under section 7, section 11, or clause A and B. My learned friend has already mentioned, Lord. D is not there. So this is one of the question. Part of the question is answered that D is not covered under 20. Fellowship get it, Lord. So therefore 20, D is not covered, Lord. Second part, Lord. It is proved that
James, I didn't follow. D, I didn't follow. What did you say?
D, 13(1)(d).
Oh, D is not included. Oh, all right, I followed.
That's it, just in the question, my lord. Reference question, my lord. 13(1)(d) is specifically mentioned.
Yes, yes.
So 13(1)(d)
is excluded from section 20. So the presumption under 20 can't be drawn insofar as D is concerned.
D is concerned.
13(1)D.
Yes.
Followed.
Now therefore, my lord, second part of the section, my lord. Now is the foundational fact. As held in the case of Lord Noor Agha's case, this honorable court has taken the view in the light of Article 20 and Article 21 and Article 14. They say we ultimately putting a burden on accused when we may upheld the provisions, but ultimately we have to interpret the law in a manner that these rights may not be tinkered with. Your Lordship, not my lord, because this is a very fundamental aspect. And on that basis, the court has held that in that situation, if two views are possible, my lord, the view in favor of the accused has to be taken. Not only on facts, but on law also. That is Noor Agha's matter, 2000.
More than February, remember. So, position that in a criminal matter, if the benefit
has to be taken is favorable to the accused.
We totally agree with you. Proceed.
This
is most fundamental thing, Mr. Jain. You
That's why,
don't.
my lord, I am not
We don't
going
need
in
a
details.
judgment for all these propositions.
I am not going in details, my lord.
All right, tell us. Proceed.
Your lord, 2008, 16 SCC 417.
All right.
Then, my lord, second part. Therefore, the second part is for drawing presumption. The condition precedent is an accused person has accepted or obtained, or has agreed to accept or attempted to. So therefore, this aspect has to be proved by the prosecution. By any evidence. I am not saying it may, but it can't be presumption against presumption. Once you draw presumption and then draw another presumption, that can't be permitted. Because phenolphthalein powder is there in the hands, then you are drawing presumption of acceptance. And once you have acceptance, there is a drawing inference of demand. That can't be permissible. And that is in one of the matter, your lordship has already mentioned, my lord, that I mentioned on page 21 of one of the order which is referenced in Nursing Rao's case, itself, my lord, I'm just putting it. Para 18, I put it for the purpose of reaching in conclusion. Not got it, please.
Yes, we got last page, last para.
Last page, last para.
Last para.
Last but one page.
Last but one page. Yeah.
For the purposes of reaching one conclusion, the court can draw delay on factual presumption unless the presumption is disproved or dispelled or rebutted. The court can treat the presumption as tantamounting to proof. However, as a caution of prudence, we have to observe that it may be unsafe to use that presumption to draw yet another discretionary presumption. So therefore, there can't be two presumptions. In nursing law case itself, it is mentioned.
There can't be double presumption.
Therefore, first you draw the presumption about motive and award.
And out of that presumption, draw one more presumption. That is barred. That is barred.
That is not.
Normal.
So therefore, 100, once 20 is out, then you can't draw presumption 114 also. Ultimately, my lord, we can't just put everything on the accused because Article 20 is there. And Article 20, if your lordship ask me a question, you explain this, and I keep silent. Your lordship, nobody can force me.
Yeah.
If nobody can force me, then in that situation, my lord, your lord should draw presumption that you can't, because of amendment in section 313. Because 313, you know, should just see that also I explained. Just see, Lord. On page 42.
It's page 14.
Just page 14. Page 14, you all should find paragraph 7, page 14, section 342 CRPC, old one below. This was the question. The accused shall not render himself liable to punishment by refusing to answer and such question. No, sorry, my lord. Accused shall not answer, shall not render himself liable to punishment by refusing to answer such question or by giving false answer to them. This the further. But the court and the jury, if any, may draw such inference from such refusal or answer as it thinks fit. Last line, Lord, is important because just see on 313.3. This line is deleted. You know, we just see now the section is the accused shall not render himself liable to punishment by refusing to answer such question or by giving false answer to them. So therefore, drawing presumption is now no more available in a 342. And in 342, the statement, Your Lordship asked me the question for drawing inference, my lord. So that is, my lord, this aspect is very much considered by Justice Jagannath Rao in his law 180th law commission report, my lord. And I quoted the report on page 15, 16, and 17.
Yes, we have. You have extensively quoted that.
I've extensively quoted it to show that these things can't be. Ultimately, presumption, right of silence is very much there. And that's why they didn't suggest any amendment in the 342 and others because of Article 20. So Article 20 is very important. I'm just not.
Yes.
Then your lordship just come to the second part of section 20. Section 20, my lord. on page 6 again, my lord. Second part is that an accused person has accepted or obtained or has agreed to accept or attempted to obtain for himself or for any other person any gratification other than legal remuneration or any valuable thing from any person. The force is on gratification, my lord. And gratification is missing in section 13(1)(d). And therefore, this is a mandatory requirement before drawing presumption. Unless this is a foundational fact.
You are
A foundational fact.
already argued that 13(1)(d) would not be applicable to section 20.
13(1)(d).
No, you have already submitted that 13(1)(d) is not applicable to section 20. Or section 20 is not applicable to 13(1)(d).
13(1)(d), my lord, is not attracted in trap matters because
You have already submitted that the presumption under section 20,
I'm sorry, my lord.
presumption under section 20 is not applicable for an office under 13(1)(d).
Right, sir.
Yes.
So therefore,
There is no question of
there is another reason I just gave, my lord.
additional factor.
This is additional reason. Because I am not arguing I'm just arguing FHM. Sometimes here, sometimes there, my lord. I'm not following my sequence, my lord, the scheme of the act. Otherwise, I would have argued the scheme of the act, then I would have argued, my lord. But I'm not arguing on that line. I'm trying to save your lordship's time.
Thank you. We are grateful to you.
No, my lord, my lord, we are here practicing here. We know your lordship's time.
Tell us.
So therefore, this is a foundational fact. Now, if this foundational fact means you have to establish acceptance, means or obtaining, which means demand. So therefore, unless these facts of demand and acceptance or demand and obtaining is established, this presumption cannot be drawn.
All right.
Then third portion is known. To what extent you can draw the presumption? Only motive or reward. So motive and reward, you can't draw a presumption with regard to demand or acceptance, which is specifically denied by the legislature. The legislature himself has decided, denied this aspect. So therefore, my lord, under 20, only motive or reward can be presumed on compliance of foundational fact then and there. That's why your lordship has laid down a number of judgments. It's a sine qua non. Demand is a sine qua non. And nobody disputed. Even the question referred does not dispute that aspect. So therefore, that is a fundamental question. So therefore, this can be done like this, my lord.
All right. We have followed.
Now, my lord, if that is the position, my lord, it's a special statute, my lord. And it is held in one of the judgment.
Special statute prevails. All right. We don't want a judgment for this.
No. I'm just putting a statement on law, my lord. I'm not taking your lordship to the law, otherwise it will take time. I'm just trying to explain my view, my lord. Then you'll just, my lord, I don't.
All right. All right.
Lord, it's a special statute. And it's held to be a complete coup. Jayalalitha's case, specifically after considering the entire scheme, the court held it's a complete code. If that is the position, my lord, then once section 20 is there, it has replaced 114. Because a special law, a special statute talks about presumption, and on the subject of presumption and in a particular condition, well, so for 20 you can't draw presumption, but 114 you will draw presumption. How can it be possible? Something can't be done directly, it can't be done indirectly, my lord. That's my only difficulty, my endeavor is that your lordships may not decide 114. That's my problem. Because if your lordship decide constitutional bench, we are gone forever.
Sir, we have repeatedly said, we will not touch all these aspects. We will not touch all these aspects. We are simply answering the question referred to, and I have told several times what questions we are going to answer. And if that we take, all these arguments are unnecessary. We will not go into the niceties as you suggested and interpretation of section 20, because that is not the question referred to us.
Yes,
we will not touch all these aspects.
On this,
Supposing if we touch all these aspects and give a judgment, you tomorrow you should come to the court and argue. We will be stopping you from.
We don't want any compliment in future. That the constitution bench has answered something which is not referred to it.
Yes. So I just
We will not touch all these questions.
Your
We
Lordship
will be only answering this question. That's all.
I am therefore putting one more thing in note.
Yes.
One or two things. I like to be Lord at beside them.
Please enlighten us only with reference to the question referred to us.
If your Lordship, Lord, by this time I have not repeated anything, nor my Lord, I have gone out of my point.
Relevant to the question referred. That's all you argue.
I am only arguing.
Relevant to the question referred.
I am only arguing on the referred question.
Yes, yes.
Then, my Lord, 114 to my learned friend Mr. Nagar has argued it is applicable. I'll just mention, my Lord, if your Lordship can come to page 10.
Page 10.
I'll only read one page or two pages. So that I'll just read it, my Lord. I'll not waste your Lord's time. It is submitted that the legislature, being aware of the existing general law in force, had incorporated a separate special provision for drawing presumption for the purposes of Act of 1988 as it under Section 20, hence applicability of Section Act would be affected by the subsequent particular or a special act. Even when the subject matter of the special act prior to its enforcement was being governed by the general provisions of the earlier act, upon enactment of later special legislation, the operation of the latter special act would have the effect of partially repealing the earlier general act so far as the present act is concerned. I'm not saying that 114 is repeal altogether. 114 so far as Prevention Corruption Act is almost partially repealed. There is a direct judgment on this point, on my Lord. Dhamji versus LIC and 1966, Supreme Court 135, and Harish Shankar Bagla versus State of Madhya Pradesh, 1955, 1 SCR 380 on interpretation. Lord, I'm just putting it in that way. Even prior to 1988 Act, Section 4, very material almost, except 161, 165, as the same. So therefore, this judgment on 1965.
See, if the question referred to us was whether
inference can be drawn.
No. If the question referred to us whether having regard to Section 20 of this Act, Prevention of Corruption Act, Section 114 has application to cases under this Act. If that was the question, we need to hear all this. We are not going to answer this. That is not the question referred.
My learned friend has argued that like that's the reason.
Let him argue, but we have told you so in clear words. When you open the case, you know.
That is actually what happened was.
Then I should not take your place.
The question posed to us. No, here. I'm here.
That is the only thing I said.
My learned brother has to say something.
We have understood the question posed to us merely because some council attempts to deflect the ball to the boundary.
Yesterday,
why do you answer all those questions, sir? You don't answer his questions. You answer only the question posed to us.
So your Lordship asked me yesterday. That's the reason. I try to prepare you.
We are making you very, very clear. See, initially, when Nagamuthu opened the case, naturally, to understand it better, no, we must have heard from all angles. But it's only to understand better. Because he opened
Sorry, my lord, if you like,
Yes.
I've taken
Please answer the question.
So opening back.
only one point.
See, opening batsman can stay there without scoring the runs also in a test match, not 2020.
Only, my lord, my blood friend lord asked me just point out paragraph 4 only. This book.
All right, paragraph 4.
2, 3,
Which page, which page?
page 7, my lord.
Page 7. All right.
For the purpose of present case, where the issue is confined to the nature of proof of demand. For the purpose of section 7 or 13(1)(d), demand of a valuable thing or pecuniary advantage either for himself or some other person is necessary ingredient. And its proof is sine qua non for bringing home a conviction under that section which is not in dispute. And B, my lord, demand of a valuable thing or pecuniary advantage can be proved by either direct oral evidence or documentary. That's my submission. Not circumstantial. That's my submission.
All this. Anything else?
I'm sorry, my lord, if I have taken a lot from you.
All right. All right. Yes, anyone wants to have?
So I want to give this one chart. We made where all, my lord, all the judgments where Satyanarayan Murthy was followed. There is a, my lord's, problem with the interpretation of Satyanarayan Murthy, your lordship.
Clarify, that we
Yes.
will clarify.
Because they are, your lordships and other, my lords, following judgments have not, where Satyanarayan Murthy is followed, they have all resulted in acquittal. The indirect evidence is not considered. So that, my lords, your lordship, and therefore the reference was necessary.
Satyanarayana Murthy, to be fair.
Yes, my lord.
Satyanarayana Murthy, they have said there is no contra evidence.
Yes.
There is a clear finding there.
Yes.
Because that is on appreciation. What evidence was there in Satyanarayana Murthy, we don't know.
Yes, my lord.
But the court has looked into the evidence and have stated that.
But my lords, the difficulty came now that your lordships are considering, kindly clarify it, because the manner in which Satyanarayan Murthy has
That
been
of course,
followed
that of course.
is this only that if direct is not there, then nothing else is considered.
Yes, that of course. We will-
So I'm not given the judgments in this, it's only an index of the judgments, because compilations I've already given, my lord.
All right, all right.
Right, sir.
Direct evidence.
Your apprehension is answered in paragraph 27 of Satyanarayan.
My lords, I bow down. In fact, your ladyship is right. Satyanarayan Murthy on a preposition of
Case means in that case, there was less evidence.
I bow down.
Adequate or insufficient evidence.
If it was wrongly applied, what can we do?
I bow down.
We are not in review.
I bow down. Your lordship is right.
Neither in review nor in appeal.
I bow down. But if your lordships will see how Satyanarayan Murthy, these are 7 judgments where Satyanarayan Murthy has.
As Mr. Rajan Basant rightly said, Raghavendra Basant, he was lucky.
Yes, your lordship is right, my lord. But then,
Like some persons are unlucky, some persons are lucky. So.
but now that your lordships are considering in constitution.
Nagamuthu, you want to add anything?
Kindly recall, my opening argument was, there is nothing
That is why we have taken so much time. So from out of nothing, so much has come. And Aishwarya Bhatti, you have actually turned the law upside down for all of us.
You will have to replace that chart.
I'm sorry, my
So you have turned the law upside down.
I'll make the correction and give to the court.
See, ultimately, demand is a sine qua non. That has to be proved for the purpose of conviction. In the absence of proof of demand, there can't be an inference regarding conviction. That is the long and short of
You
this
have
case.
created a hostile, don't
But demand can be proved by other means rather than direct.
Yeah.
That is what is the reference.
And the presumption under section 20,
That's right.
legal presumption, is shall presume. Whereas the presumption under section 114, it is a presumption in fact. That is the difference. The two are not the same.
Any rate, neither can there be a legal presumption or factual presumption of demand.
Yes.
He is to prove independent.
Ms. Sood, you want to add? Where is Karpaga Vinayagam? You want to say, sir, something?
Correctly, Justice would say, demand is very essential, my lord, and receipt also essential. receipt in person the demand. Demand can be proved by complainant or other evidence. So in the absence of the complainant, we can look into other evidence in order to find out any indication or any evidence relating to demand is there. Demand receipt is there, conviction. No demand is there, acquittal.
And you said one more important point. Once the complainant dies,
yes,
you know, nobody to mark his complaint.
Yes,
How to prove the complaint?
The complaint cannot be marked at all.
Guilt.
Yes, yes.
By presuming lot of.
Demand is a symptom.
Unless they amend the law.
Where is Basant? He wants to say something? Basant made some important point.
No, the only point made all of you is acquit all accused. In corrupted cases.
We will not argue further.
But that question is not referred to us, huh?
Thankfully, it is.
In fact, one thing, Nursing judgment and all, there is a purely 1 and 2 turned hostile. Accused stated in 313 suffered the packet. And DW1 and TW2, they give evidence, the accused was absent, the accused was not available alibi. In that case, conviction was entered into.
Nagamuthu, one important question Mr. Jain raised in an appropriate case, probably you people have to answer. No second presumption. Because he said, you know, having regard to section 20, which is a complete code in itself, you can't bring in 114. This is what he said. Of course, we are not going to answer, but that is what.
Regarding the legal position, there can't be a presumption, out of a presumption.
No, he said, when he says this PC Act is a complete code, section 20, presumption, end of the matter, don't bring in your evidence act.
They are only one sharply.
This is what he said.
So that regarding the fundamental legal principle, that there can't be a presumption out of a presumption. But there is no quarrel. Now here, 20 is in respect of only one aspect.
Yes.
It is shall presume.
Yes.
Whereas 114 is may presume, factual presumption. What is not covered under section 20 can be covered by section 114.
He has opposition for that.
That can't be done. It doesn't exclude.
Anyhow, we are not going to answer, luckily today, but this is a question one day you have to answer. Yes. All right, thank you so much.
On behalf of all, express our gratitude to Lordship for having so patient. Really very interesting.
Patient hearing, even though your Lordship said 2 minutes, we have allowed to argue on 15 minutes, 20 minutes.
That's why he's, in other words, he's telling you are not so patient today. This is what he said.
I never, I can't, for your Lordships, I can't do that.
All right, sir. Thank you. Thank you. All right, file. Within 3 days, right? Within 3 days.